Understanding the Workplace Safety Code. What is the Occupational Safety, Health and Working Conditions Code? A unified legislation that consolidates 13 previously separate workplace safety laws, a framework designed to enhance workplace safety and improve working conditions across India, a balanced approach that simplifies regulatory compliance while strengthening worker protections. Why was this new code created? To modernize and simplify India's complex labor regulatory landscape, to establish a proactive safety culture that prevents workplace hazards before incidents occur, to adapt regulations to emerging employment models in the contemporary economy. Who benefits from this code? Approximately 500 million workers gain enhanced protection against workplace hazards. Employers benefit from streamlined compliance requirements and simplified registration procedures, fostering business efficiency. What are the main features of the code? Unified registration system for all business entities, mandatory annual health examinations for workers at no cost, mandatory safety officers in establishments above specified size thresholds, enhanced protections for women workers, including optional night shift opportunities, standardized 8-hour workday with overtime compensation provisions, mandatory employment contracts for all workers, specialized safety protocols for hazardous occupations, interstate migrant worker allowances and protections, technology-enabled inspection systems to ensure impartial enforcement. How will the code be implemented? Through a 3-tiered governance structure: National Occupational Safety and Health Board at the central level, corresponding state-level safety boards, workplace safety committees in establishments with 250-plus workers. This multi-level framework ensures comprehensive safety oversight across diverse workplace environments. How does this code empower women workers? Provides women with night shift opportunities supported by appropriate safety measures and transportation mandates, adequate facilities and safeguards against discrimination in the workplace. What tangible changes will workers experience? Formalized employment through mandatory appointment letters, regulated working hours with fair compensation for overtime, access to preventive health care through annual medical examinations, enhanced workplace safety through improved equipment and training, additional protections for workers in high-risk occupations, financial support and improved living conditions for interstate migrant workers. How does the code leverage technology? Implements digital inspection systems and electronic record management, utilizes data analytics to identify high-risk workplaces for targeted monitoring, enhances transparency, reduces corruption, and improves safety oversight without unnecessary business disruption. The Workplace Safety Code streamlines India's labor regulations by consolidating 13 separate laws into one comprehensive framework. It enhances protection for workers across all sectors while simplifying compliance procedures for employers through health initiatives, targeted safety protocols, women's empowerment measures, and technology-driven monitoring systems. Frequently asked questions. Below are answers to common questions about the Workplace Safety Code, designed to provide clarity on this transformative legislation. What is the Occupational Safety, Health and Working Conditions Code? This innovative legislation unifies 13 previously separate workplace safety laws into a single, coherent framework. It simultaneously strengthens worker protections and reduces regulatory complexity for employers. Which older laws does this code replace? The code consolidates 13 distinct legislations, including the Factories Act, 1948, Mines Act, 1952, Contract Labor Act, 1970, and Building Workers Act, 1996, creating a unified regulatory environment that eliminates confusion and overlapping requirements. Who is covered under this code? The code extends comprehensive protection to workers across all sectors in India, including manufacturing, mining, construction, agriculture, and service industries. Its provisions safeguard permanent employees, contract workers, and interstate migrant laborers alike. What protections does the code offer to workers? Workers benefit from mandatory health assessments, specialized safety training, provision of protective equipment, regulated working hours with mandatory rest periods, and accessible grievance mechanisms. Heightened safeguards apply to hazardous occupations, with strict compliance requirements for employers. How does the code use technology to improve safety? The code leverages digital solutions including web-based inspections, electronic permitting systems, and computerized record management. This technological integration enhances transparency, expedites processes, and enables risk-based inspection targeting to prioritize high-hazard workplaces. How does the code help women workers? The code promotes gender equality through balanced opportunity policies and customized safety protocols. Women gain the option to work night shifts with appropriate safeguards, access to essential facilities including restrooms and childcare services, protection against discrimination, and guaranteed representation in workplace safety committees. What changes will employers notice with this new code? Employers will experience streamlined regulatory compliance with a consolidated set of obligations replacing the previous fragmented system. The code maintains robust safety standards while reducing administrative complexity through simplified procedures and clearer guidelines. How does the code benefit the economy? Regulatory simplification enhances business efficiency and operational productivity. Improved workplace safety reduces accident rates and associated downtime, while better health provisions minimize absenteeism and boost workforce productivity. This creates a foundation for sustainable economic growth without compromising worker welfare. This landmark legislation represents a significant advancement in India's labor law framework, establishing a proactive hazard prevention system that balances worker protection with business-friendly regulatory practices. Frequently asked questions: when and where the code applies. The code will be implemented gradually across India, except in government offices and warships, with official notifications preceding implementation. Different provisions may take effect on different dates, and the law will protect contract workers even in otherwise exempt settings. Here are answers to common questions about the temporal and geographical scope of the new workplace safety law. When will the code become effective? The code will become effective on a date determined by the central government. They will issue an official notification in advance to allow adequate preparation time for all stakeholders. Will the entire code be implemented simultaneously? No. Different provisions may be implemented on different dates. This phased approach enables smoother transition to the new regulatory framework without disrupting operations. High-risk industries may need to comply with certain provisions earlier than others. Does the code apply to all workplaces? The code applies to most workplaces throughout India, with exceptions for central government offices, state government offices, and warships. These exempt entities operate under their own specialized safety regulations. Are contract workers in government offices covered? Yes, contract workers in government offices are protected by this code. While government offices themselves are exempt from the code's provisions, the contract workers employed within these facilities receive all the safety protections guaranteed by the code. Does the code have nationwide applicability? Yes, the code applies uniformly across the entire country, including Jammu and Kashmir. This establishes consistent safety standards nationwide, though states retain authority to formulate certain rules addressing specific regional requirements. How will the code's implementation be communicated? The government will publish an official notification and present it to Parliament. Industry associations and labor unions typically receive advance notice to prepare their members for the forthcoming changes. What preparations should employers make before implementation? Employers should conduct a gap analysis comparing their current safety practices with the code's requirements. This assessment facilitates planning for necessary adjustments. The government has established dedicated helplines to support organizations during this transition period. What should workers understand during this transition period? Workers should familiarize themselves with their new rights and protections. This knowledge helps ensure proper implementation at their workplaces. Workers can also access government helplines for information regarding how the code safeguards their interests. Frequently asked questions. Key definitions under the code. The code defines critical elements: establishments, workplaces with 10+ workers, employees, all paid workers regardless of role, employers, those responsible for hiring and workplace management, and factories, manufacturing facilities with 20+ workers using machinery or 40+ without. Below are essential terms from the safety code explained in straightforward language. What is an establishment under the code? An establishment refers to any workplace employing 10 or more workers. This encompasses factories, construction sites, offices, farms, mines, and service-oriented businesses such as banks, hospitals, and educational institutions. Temporary work sites and businesses with multiple locations also qualify as establishments under the code. Who is considered an employee under the code? An employee includes anyone performing work for compensation. This broad definition covers full-time and part-time staff, contract workers, apprentices, trainees, and gig economy workers. The code protects all workers regardless of skill level or job type, from office personnel to manual laborers. Who is an employer according to the code? An employer is the individual responsible for worker recruitment and workplace operations. This may be the owner, managing director, or primary contractor. In government institutions, the department head typically serves as the employer. Employers bear responsibility for implementing safety regulations, maintaining accurate documentation, and ensuring suitable working conditions. What makes a workplace a factory under the code? A factory is defined as a manufacturing facility employing either 20-plus workers with machinery or 40-plus workers without machinery. This classification includes manufacturing goods, power generation, printing operations, software development, and repair facilities. The definition encompasses all related spaces such as warehouses and canteens. Military establishments, railway workshops, hotels, and restaurants are specifically excluded from this definition. Understanding these definitions clarifies which workplaces and workers receive protection under the code. If you're uncertain about your workplace's classification, consult a labor law specialist or your regional labor office for guidance. Registration requirements. Frequently asked questions. All workplaces with 10-plus workers must register online within 60 days. The process requires identity and business documentation. Certificates must be displayed, remain valid indefinitely, and businesses must report any changes within 30 days. Non-compliance can result in hefty fines or imprisonment. Below are clear answers to common questions about registration under the Occupational Safety, Health and Working Conditions Code, 2020. Who needs to register under the code? All workplaces with 10 or more workers must register, including factories, offices, shops, construction sites, and any business premises. When should I apply for registration? Apply within 60 days from when the code becomes applicable to your workplace. Start early as processing requires time. What documents do I need for registration? You'll need identity proof, Aadhaar, PAN card, address verification, electricity bills, property documents, business details, and compliance certifications for other regulations. Workplaces handling hazardous materials must provide safety protocols. How do I submit my application? All applications must be submitted online through the official portal. The new code no longer accepts paper applications. How long does it take to get registered? Registration certificates are typically issued within 30 working days of submitting a complete application. If authorities don't respond within this time frame, your registration is automatically approved. What should I do with the registration certificate? Display the certificate prominently at your workplace for visibility to all. Keep it accessible for inspections. The certificate contains a unique ID number required for all Labor Department communications. How long is my registration valid? Your registration remains valid for the lifetime of your business. However, certain documents may require periodic updates according to state regulations. What if something changes in my business? Report any changes to ownership, management, business activities, workforce size, or physical structure within 30 days. Submit updates online with supporting documentation. Certain changes may incur additional fees. What should I do when closing my business? Notify authorities within 30 days of closure. You must verify full settlement of worker dues and provide documentation of final payments and termination notices. What happens if I don't register or follow these requirements? Penalties include fines up to 1 lakh rupees. Repeat violations may result in imprisonment up to 6 months, revocation of business licenses, and disqualification from government contracts. Registration is a legal requirement, not optional. Note that while the code allows self-certification, labor officials will conduct regular and surprise inspections. Maintaining thorough documentation and fulfilling all obligations will help your business avoid penalties and legal complications. Frequently asked questions. Deemed registration automatically approves your application if officials don't respond within 45 days. This system generates a legally valid digital certificate and protects businesses from administrative delays while maintaining regulatory compliance. Here are straightforward answers to common questions about deemed registration under the Occupational Safety, Health and Working Conditions Code. What is deemed registration? Deemed registration is an automatic approval mechanism that considers your business officially registered if authorities fail to process your complete application within the stipulated time frame. This safeguards your business operations from bureaucratic bottlenecks. When does deemed registration take effect? Your business receives deemed registration status automatically after 45 days of application submission if no decision is communicated to you. No additional paperwork or follow-up applications are required from your end. How will I receive my registration certificate? The system automatically generates a digital certificate that becomes available for download through the official portal. This digital certificate contains a unique identification number and QR code for verification purposes and holds full legal validity. Is a deemed registration certificate legally equivalent to a standard certificate? Yes, a deemed registration certificate carries identical legal weight as a regularly issued certificate. Financial institutions, government departments, and regulatory bodies must accept it for all official purposes including loan applications, license procurement, and government tenders. Who bears responsibility for registration delays? The designated registration officer holds accountability for processing delays. The code includes provisions for administrative action against officials who demonstrate a pattern of unnecessary delays in application processing. What documentation should I maintain to support a deemed registration claim? Preserve comprehensive records of your application submission, including date-stamped receipts, acknowledgement numbers, communication records with the registration office, and proof of document uploads. This documentation serves as crucial evidence should you need to validate your application timeline. The deemed registration provision represents a significant step toward reducing regulatory compliance burdens through digital governance. It aligns with the government's broader initiative to foster an efficient business ecosystem while maintaining necessary oversight. Frequently asked questions, appeals against registration decisions. The appeals process allows parties to challenge registration decisions within 30 days by submitting documentation and fees. After a hearing, the appellate officer provides a binding written decision within 30 days. Simple answers to common questions about appealing registration decisions. Who can file an appeal? Anyone affected by a registration decision can appeal, including employers whose applications were denied or individuals impacted by an approval. How do I file an appeal? Submit your appeal to the appellate officer within 30 days of receiving the decision. Complete the required form, attach supporting documents, and clearly explain why you believe the decision was incorrect and how it affects you. What if I miss the 30-day deadline? You may file a late appeal with valid justifications such as serious illness or natural disaster. The appellate officer will determine if your reason warrants acceptance of the late filing. Is there a fee for filing an appeal? Yes, a government set fee must accompany your appeal. Pay online through the official website and keep your receipt. Fee amounts may vary based on circumstances, and waivers may be available in cases of financial hardship. What happens during the appeal process? You'll present your case at a hearing, in person or via video, while the original decision-maker explains their reasoning. The appellate officer must issue a decision within 30 days, though complex cases may require additional time. What kind of decision will I receive? You'll receive a written decision that upholds, modifies, or reverses the original decision, with explanations and next steps. If successful, the officer may direct the registering authority to issue or modify your certificate within a specified time frame. Is the appeal decision final? The decision is binding unless challenged at a higher level. It also serves as precedent for similar future cases, helping ensure consistency and fairness in the registration system. This appeals system ensures fair treatment during registration by providing an important check against improper decisions, while maintaining the integrity of the registration process. Notice of commencement and cessation. Frequently asked questions. Businesses such as factories, mines, and construction operations must notify authorities before initiating operations and upon closure. These notifications include detailed information about operations, workforce, and safety protocols, with specific timing requirements. Proper notifications facilitate regulatory oversight and demonstrate legal compliance. Here are straightforward answers about notifying authorities when your business begins or ends operations under the safety code. What is a notice of commencement? It's an official notification submitted to regulatory authorities before starting business operations. This enables authorities to monitor active businesses and verify compliance with safety regulations. Which businesses need to submit these notices? Notices are mandatory for factories, mining operations, businesses using contract workers, and construction projects. This requirement applies to all applicable businesses regardless of size. What information must I include? Your notice should detail the nature of operations, anticipated workforce size, equipment and machinery to be utilized, and comprehensive safety protocols. Even temporary or short-term operations must fulfill this notification requirement. How do I submit my notice? Submit electronically through the official government portal. This method provides faster processing and confirmation of receipt. You may need to attach supporting documentation such as business registration certificates, property documents, safety certifications, and safety officer credentials. When should I send my notice? Submit within the time frame specified by your local regulatory authority typically 15 to 30 days before commencing operations. Late submissions may incur financial penalties or operational delays. Do I need to notify authorities when I stop operations? Yes, notification is required for permanent closure, temporary suspension, or significant operational changes. What should my cessation notice include? A cessation notice should explain the reason for closure and outline worker compensation plans. You may need to include details about final settlements, safe disposal of hazardous materials, equipment decommissioning, and site remediation. Why are these notices important? These notifications enable authorities to maintain accurate records, conduct appropriate inspections, and enforce safety compliance. They also help government agencies collect statistical data, monitor employment trends, and identify areas requiring enhanced safety regulations. Submitting proper notices demonstrates your business's commitment to legal compliance, worker protection, and public safety. This practice fosters a relationship of trust between your enterprise and regulatory authorities. Frequently asked questions, employer duties. Common questions about workplace safety responsibilities. Under the code, employers must create hazard-free workplaces, comply with safety standards, provide health checkups, ensure safe environments, manage hazardous waste, deliver safety training, prepare for emergencies, and handle workplace incidents appropriately. What must employers do to create a hazard-free workplace? Employers must maintain a workplace free from hazards. This includes regular equipment inspections, proper building maintenance, and accident prevention. Quarterly risk assessments are required, with documentation of identified hazards and mitigation plans. Special attention should focus on high-risk areas like electrical systems, chemical storage, and machinery. How should employers comply with safety standards? Employers must adhere to all code safety regulations. This includes staying informed about regulatory updates, conducting compliance audits, and promptly addressing violations. Designated personnel should track regulatory changes, maintain compliance records, and cooperate with inspectors. Non-compliance can result in significant penalties, operational restrictions, or legal liability. Are employers required to provide health checkups? Yes, employers must provide free annual health assessments for all workers. These examinations should address job-specific health risks, with comprehensive records maintained for each worker. Occupational health specialists should conduct these assessments. Workers exposed to hazards like noise, chemicals, or radiation require specialized testing. All medical records must remain confidential and be retained for at least 5 years after employment ends. What makes a safe working environment? A safe workplace requires adequate ventilation, appropriate lighting, comfortable temperature control, ergonomic workstations, and regular safety drills. Working conditions must be monitored and documented regularly. Workspaces should accommodate all workers, including those with physical limitations. Employers should solicit worker feedback to identify safety concerns that management might overlook. How should hazardous waste be handled? Employers must safely dispose of hazardous materials, including electronic waste. This requires implementing effective waste management protocols, partnering with certified disposal services, and maintaining disposal documentation. Clear waste segregation procedures must be established and communicated to all workers. Facilities generating significant hazardous waste must maintain designated storage areas. Organizations should pursue waste reduction strategies that align with environmental objectives and regulatory requirements. What kind of safety training should employers provide? Employers must conduct regular safety training covering workplace hazards, preventive measures, emergency protocols, and proper use of safety equipment. All training must be documented. Training should combine theoretical instruction with practical application. New employees require orientation before beginning work, while existing staff need refresher training. Workers in high-risk areas require specialized instruction. Assessment methods should verify comprehension of training content. How should employers prepare for emergencies? Employers must develop and implement emergency response plans for fires, natural disasters, and medical emergencies. This includes installing safety equipment, marking evacuation routes, and establishing emergency response teams. Plans must be documented, regularly updated, and prominently displayed. Practice drills must occur at least twice yearly. Emergency equipment like first aid kits, fire extinguishers, and defibrillators must be strategically located, regularly inspected, and properly maintained. What should be done about workplace accidents and incidents? Employers must establish clear protocols for reporting workplace accidents, injuries, and near misses. All incidents must be investigated, documented, and addressed with corrective actions. Reporting systems should be accessible and designed to encourage honest reporting without fear of retaliation. Serious incidents requiring medical attention or resulting in lost workdays must be promptly reported to authorities. Incident data should undergo quarterly analysis to identify patterns and develop prevention strategies. Frequently asked questions about employer duties. Employers bear legal responsibility for workplace safety, must provide safety equipment at no cost to workers, and are required to maintain comprehensive documentation. Their safety obligations extend to all individuals present at the workplace, not exclusively employees. Below are commonly asked questions regarding employer obligations for maintaining workplace safety. What essential information must be included in an appointment letter? An appointment letter must clearly specify job title, responsibilities, commencement date, compensation, working hours, leave entitlements, benefits package, workplace policies, grievance reporting procedures, notice period requirements, and confidentiality provisions. Employers are legally obligated to provide this document to all workers within 3 months of the regulations taking effect. Are employers permitted to charge workers for safety equipment? Absolutely not. Employers must bear all costs associated with workplace safety measures. This financial responsibility encompasses personal protective equipment, health assessments, safety training programs, workplace inspections, emergency response equipment, and hazardous waste management. Under no circumstances should workers incur expenses for any safety-related requirements, for whose safety is an employer legally responsible. Employers must ensure the safety of everyone present in the workplace environment. This responsibility extends to permanent employees, temporary staff, independent contractors, site visitors, clients, interns, trainees, and regulatory inspectors. The duty of care applies to any individual who might be affected by workplace activities, regardless of their employment relationship with the company. What are the core safety responsibilities of employers? Employers must conduct regular hazard assessments, implement accident prevention measures, document and report incidents, provide appropriate emergency equipment, deliver comprehensive worker training, maintain clear safety communication, develop detailed safety protocols, perform scheduled safety audits, and maintain thorough safety documentation. Can safety responsibilities be delegated to managers instead of employers? No. Even when specific safety functions are delegated to management personnel, the employer retains ultimate legal accountability. The delegation of safety tasks does not diminish or transfer the employer's fundamental responsibility for ensuring workplace safety compliance. What is the required retention period for appointment letters and safety records? Employers must preserve appointment letters and all safety-related documentation for a minimum of 5 years following the termination of a worker's employment. These records may be requisitioned during compliance audits, workplace investigations, or legal proceedings that occur years after an employee's departure. Common questions about safety in dangerous work. This comprehensive guide addresses critical safety responsibilities in high-risk industries, including equipment maintenance, hazardous materials management, worker training protocols, workplace organization standards, occupational health requirements, and penalties for non-compliance. Below are detailed answers to frequently asked questions about safety regulations governing high-risk occupations such as construction, mining, manufacturing, and chemical processing. How do I keep equipment and machines safe? Equipment safety requires systematic implementation of these measures, conducting regular equipment inspections and maintenance, establishing clear operating procedures for all machinery, performing comprehensive hazard assessments, installing appropriate machine guards and emergency stop mechanisms, maintaining complete equipment certification documentation, implementing scheduled safety audits. How do I handle dangerous materials? Hazardous materials require stringent protocols for handling, storage, and transportation. Developing standardized procedures for hazardous substance handling, ensuring clear labeling on all dangerous materials, maintaining properly ventilated storage facilities, implementing comprehensive spill response protocols, providing readily accessible safety data sheets displaying chemical segregation charts in relevant areas, conducting specialized training for hazardous materials handlers, designating secure routes for hazardous material transportation. What training do workers need? Effective worker safety training must include comprehensive safety orientation for all new personnel, specialized training for high-risk positions, regularly scheduled refresher courses, supervision by qualified safety leaders, detailed documentation of training, participation competency assessments to verify understanding emergency response procedure, training clear protocols. For reporting unsafe conditions, how do I keep the workplace safe? Workplace organization must prioritize these safety elements: maintaining obstruction-free pathways and circulation areas, installing adequate illumination throughout all work zones, conducting regular flooring and surface inspections, ensuring properly maintained emergency exits, installing appropriate guardrails and fall protection systems, clearly delineating pedestrian walkways, implementing regular housekeeping procedures, displaying visible evacuation plans and signage, clearly marking load capacity limits for elevated areas. What makes a healthy workplace? Occupational health standards require these environmental and facility considerations: maintaining appropriate air quality, temperature regulation, and noise control, implementing regular environmental monitoring protocols, ensuring adequate ventilation and illumination systems, providing sanitary restrooms and hand-washing facilities, supplying potable water and fully stocked first aid stations, designating break areas separate from production zones, providing appropriate changing facilities and personal storage, implementing measures to mitigate workplace stress. What if I don't follow these safety rules? Non-compliance with safety regulations carries significant consequences: substantial financial penalties scaled to organization size, operational shutdown until remediation is complete, criminal charges against responsible management personnel, civil litigation from injured workers, increased insurance premiums, reputational damage affecting stakeholder relations, suspension or revocation of operational licenses, potential incarceration for severe negligence resulting in harm. Maintain comprehensive documentation of all safety initiatives as evidence of regulatory compliance. Consider pursuing safety certifications such as ISO 45001 to demonstrate organizational commitment to workplace safety excellence. Common questions about mining safety responsibilities. Mining safety is a shared responsibility among owners, managers, and supervisors with strict accountability measures. No one can avoid liability, and all parties must work together to implement comprehensive safety systems. Mining operations present significant hazards. Effective safety regulations help protect workers from these dangers. Here are answers to key questions about responsibility for maintaining mine safety. Who is responsible for safety in mines? Both mine owners and appointed agents, those in management positions, share responsibility for safety. They can be held accountable jointly or individually if safety regulations are violated. Mine ownership and operational management must collaborate effectively to ensure workplace safety for all personnel. What happens if a supervisor fails to maintain safety? Supervisors are presumed responsible when safety violations occur in their areas of oversight, unless they can demonstrate they took all reasonable measures to prevent such violations. They must maintain comprehensive documentation of safety inspections, worker training, and corrective actions taken to address identified hazards. What are the mine manager's responsibilities? The manager must ensure compliance with all safety regulations. This includes implementing robust safety systems, conducting regular inspections, identifying potential risks, and providing thorough worker training. Managers must establish effective hazard reporting procedures and maintain current, accurate safety documentation. Can owners avoid responsibility by hiring managers? No. Delegating operational authority to managers does not relieve owners of their fundamental duty to ensure workplace safety. Even when owners assign daily operational oversight to others, they remain legally responsible for safety violations. Owners must maintain active involvement in safety governance. Why does mining have such strict safety rules? Mining involves exceptional hazards unique to the industry. The stringent regulations create multiple layers of accountability to enhance worker protection. When responsibility is distributed across all levels from ownership to direct supervision, safety becomes a consistent priority rather than an afterthought. How can mines meet these safety responsibilities? Effective compliance requires systematic safety inspections, transparent hazard reporting mechanisms, and clear communication channels between all workers and management. Successful safety programs demand collaborative effort from everyone involved. The Mining Safety Code requires documented evidence of responsibility assignment and verification that all parties are fulfilling their designated safety obligations. Frequently asked questions: duties of manufacturers, importers and suppliers. Manufacturers, importers, and suppliers must ensure product safety through proper design, testing, documentation, and ongoing monitoring. Failing to meet these responsibilities can result in serious legal and business consequences. Key questions regarding safety responsibilities in industrial settings. What are the main safety duties for manufacturers, importers, and suppliers? These entities must ensure product safety, conduct thorough testing, provide comprehensive usage instructions, actively monitor for safety issues, and maintain detailed records. These practices protect end users and ensure regulatory compliance. How should products be designed and constructed? Products must maintain safety under intended use conditions. Organizations should utilize quality materials, adhere to industry standards, incorporate appropriate safety features, and ensure structural integrity throughout the product's expected lifespan. What testing is required for industrial products? Companies must implement rigorous testing protocols before and during production. Testing should evaluate normal operation, potential misuse scenarios, durability factors, and compatibility with other equipment. All test documentation must be preserved for verification. What information must be provided with products? Products require comprehensive safety documentation, including detailed user manuals, prominent warning labels, and technical specifications. This information should be accessible, available in relevant languages, and incorporate standardized safety symbols to highlight critical warnings. What ongoing safety research is needed? Organizations must continuously evaluate product safety. This involves analyzing customer feedback, investigating reported incidents, staying current with safety research, and monitoring regulatory developments. Product improvements should be implemented promptly when safety concerns are identified. What documentation must be maintained? Companies must preserve comprehensive records demonstrating compliance with safety regulations. This includes test certifications, declarations of conformity, and safety assessment reports. Documentation should be systematically organized, regularly updated, and readily accessible for regulatory inspections. What happens if companies don't follow these safety duties? Non-compliance may result in financial penalties, mandatory product recalls, and liability for injuries. Organizations may face production suspensions, market access restrictions, or criminal prosecution in severe cases. Reputational damage can have lasting negative impacts on business operations. Frequently asked questions: importing products to India. Imported products must comply with both Indian and country of origin standards, whichever is stricter. Importers must maintain comprehensive documentation, ensure ongoing product safety, and provide adequate after-sales support. Non-compliance can result in severe penalties. What standards must imported products meet in India? Imported products must comply with the same quality and safety standards as domestically manufactured products. These standards are established by the Bureau of Indian Standards, BIS, and other regulatory agencies. Products must undergo testing and receive proper certification before entering the market. Particularly stringent regulations apply to electronics, food products, textiles, and children's toys. What if the standards in the product's home country are higher than India's? When standards in the country of origin exceed Indian requirements, products must still adhere to those higher standards. This policy prevents the import of substandard products into India. For instance, imported vehicles must maintain all original safety features, even when Indian regulations don't mandate them. Similarly, pharmaceutical products must maintain their original quality standards when these exceed Indian requirements. What happens if India doesn't have standards for a particular product? In the absence of specific Indian standards, products must comply with standards from their country of origin. Importers must provide documentation verifying compliance with these international standards. This typically applies to emerging technologies and specialized equipment. Importers may need to furnish technical specifications, certification documents, and evidence of safe use in other markets. What documentation do importers need to maintain? Importers must maintain comprehensive records including test reports, certification documents, and compliance evidence. These documents should be readily accessible for inspection by customs authorities. Essential documentation includes certificates of origin, technical specifications, safety data, user manuals, and quality assessment reports. All documentation must be provided in English or accompanied by certified translations. What are importers' responsibilities after products enter India? Importers retain responsibility for their products post-customs clearance. They must conduct regular quality checks, address safety concerns promptly, and implement product recalls when necessary. Importers should establish systems for product tracking, customer complaint management, and timely reporting of serious issues to regulatory authorities. Additionally, they must provide after-sales service, spare parts availability, and warranty support as mandated by law. Failure to comply with these regulations can result in serious consequences, including product confiscation, import restrictions, financial penalties, and criminal prosecution if public safety is compromised. We strongly advise importers to verify compliance prior to importation and consult with regulatory experts when dealing with complex product categories. Common questions about architect and engineer safety duties. Architects and engineers bear critical safety responsibilities throughout a building's life cycle. From conceptual design to long-term maintenance, they must identify potential hazards, eliminate dangerous elements in designs, and ensure buildings can be safely maintained for their intended lifespan. Here are answers to common questions about safety duties for building professionals. What safety duties do architects and engineers have during planning? Architects and engineers must integrate worker safety considerations from project inception. They need to conduct comprehensive hazard assessments before construction commences, consult with safety specialists during design development, incorporate robust safety features in their technical specifications, document detailed safety protocols and distribute them to all stakeholders, maintain current knowledge of safety regulations and building codes, implement comprehensive fire protection and emergency evacuation strategies. What dangerous elements must architects and engineers avoid in their designs? Building professionals must eliminate structural vulnerabilities that could compromise building integrity, hazardous materials that pose risks to construction workers, designs requiring high-risk construction methodologies, materials known to cause long-term health complications, inadequate ventilation systems that create poor indoor air quality, insufficient lighting that could contribute to workplace accidents, substandard foundation designs that undermine structural stability unnecessarily, complex designs that increase worker exposure to danger when hazardous elements cannot be eliminated. They must provide comprehensive safety mitigation protocols. How should architects and engineers plan for building maintenance safety? They must anticipate ongoing maintenance requirements by designing secure access points for routine maintenance operations, incorporating certified anchor points for facade maintenance and cleaning, ensuring mechanical and electrical systems are safely serviceable, developing comprehensive maintenance manuals that clearly identify potential hazards, designing with future renovations and modifications in mind, installing permanent fall protection systems on rooftops and elevated areas, designing mechanical rooms with adequate clearance for safe operation, engineering structures to accommodate maintenance equipment loads, providing thorough as-built documentation to prevent future safety incidents. Frequently asked questions. Accident reporting. Workplace accidents require specific reporting procedures. Fatalities, serious injuries, near misses, and dangerous occurrences must be reported promptly by employers, with comprehensive records maintained. Investigations follow fatal accidents, and proper documentation helps prevent future incidents. What types of workplace accidents must be reported? Any accident resulting in a fatality, injuries that prevent an employee from working for more than 48 hours, near-miss incidents that could have caused serious harm, dangerous occurrences, even without resulting injuries, specific work-related illnesses outlined in regulations, incidents involving hazardous substances, equipment failures or structural collapses, hazardous electrical incidents, exposure to biological agents or radiation hazards. Who is responsible for reporting workplace accidents? The employer, owner, agent, or manager bears reporting responsibility and must notify authorities immediately about any fatalities, submit a written report within 24 hours for serious incidents, maintain detailed accident records for a minimum of 5 years, provide comprehensive facts about the incident, utilize the appropriate official forms, document witness statements, accurately preserve evidence, and keep the accident scene unaltered when feasible, notify insurance providers as required, inform affected workers and their representatives. What happens after a fatal accident at a workplace? For fatal accidents in plantations or construction sites, authorities must conduct an investigation within 2 months, which includes official inspection of the accident site, collection of statements and evidence, verification of compliance with safety regulations, assessment of failed safety measures, examination of equipment and materials involved, review of training records and safety documentation, consultation with subject matter experts, when necessary, preparation of a formal report with recommendations, implementation of preventative measures against similar accidents. Why is accident reporting important? Effective accident reporting extends beyond regulatory compliance. It helps prevent similar incidents by identifying patterns and addressing root causes. Organizations should train all personnel on reporting procedures and foster an environment where workers feel secure reporting incidents without fear of repercussion. Regular analysis of accident data helps identify trends and systemic issues. Safety teams should evaluate the effectiveness of current reporting mechanisms and recommend improvements when necessary. Frequently asked questions, reporting dangerous events and workplace illnesses. This guide outlines mandatory reporting requirements for workplace incidents and illnesses, detailing reportable events, submission deadlines, medical practitioners' obligations, and the comprehensive benefits of thorough incident documentation. Essential information about reporting workplace incidents and occupational health conditions. What dangerous events must be reported? Serious workplace incidents require reporting even when no injuries occur. These include crane or lifting equipment failures, explosions or fires, structural collapses, significant electrical malfunctions, hazardous chemical releases, respiratory protection equipment failures, accidental contact with overhead power lines, dangerous gas leaks or releases, railway or transport accidents within the workplace. When should dangerous events be reported? Notify authorities within 24 hours of the incident. Submit a comprehensive report within 7 days that documents a detailed description of the incident, root cause analysis, findings, preventive measures implemented to avoid recurrence. Non-compliance with reporting requirements may result in financial penalties or legal proceedings. What occupational illnesses must be reported? Report all conditions listed in the third schedule upon medical diagnosis. These include chemical or toxic substance poisoning, occupational lung or respiratory diseases, work-related carcinomas or cancers, noise-induced hearing impairment, occupational dermatological conditions, effects of radiation exposure, work-related respiratory disorders, musculoskeletal disorders from repetitive motions. How quickly must occupational illnesses be reported? Submit reports within 7 days of receiving the diagnosis. Maintain comprehensive records for a minimum of 5 years documenting nature and duration of exposure, employees' work history and tenure, protective measures and controls implemented. What are medical practitioners' reporting obligations? Physicians must report occupational illnesses to the Chief Inspector cum Facilitator by submitting Form 33 within 48 hours of diagnosis. The report must include complete medical diagnosis, probable workplace causes, estimated recovery period, prescribed treatment protocol. Non-reporting physicians may face penalties of up to 10,000 rupees. Why does reporting matter beyond regulatory compliance? Effective reporting systems identify systemic safety vulnerabilities and inform improved safety protocols, prevent similar exposures among the workforce, contribute valuable data to occupational health research, guide evidence-based policy development, substantiate workers' compensation and benefit claims. Frequently asked questions, employee safety duties, essential questions about your workplace safety responsibilities with clear, actionable answers. Employees must exercise reasonable care, adhere to safety protocols, collaborate with employers on safety initiatives, promptly report hazardous conditions, properly utilize equipment, understand emergency procedures, and maintain personal health standards that support workplace safety. What does take reasonable care mean for employees? It means conducting yourself safely to protect both yourself and colleagues. Follow established safety protocols, wear appropriate protective equipment, remain vigilant, and consider how your actions might impact others. Arrive at work well rested and free from the influence of substances that could impair judgment. How do I comply with safety requirements? Adhere to all safety regulations and complete required training thoroughly. Maintain current safety certifications and don't hesitate to seek clarification when safety procedures seem unclear. How should I cooperate with my employer on safety matters? Actively participate in safety meetings and risk identification processes. Provide constructive feedback on safety initiatives, support improvement efforts, engage in safety inspections when requested, and propose practical solutions to identified safety concerns. What should I do if I notice an unsafe situation? Immediately alert your supervisor with specific details about the hazard, including its location and potential dangers. Document the issue with photographs when possible and follow up if remediation doesn't occur promptly. How should I use safety equipment properly? Utilize tools exclusively for their intended purpose and according to manufacturer guidelines. Report any damage or malfunction immediately. Never disable safety features. Inspect equipment before each use, and refrain from operating compromised equipment. What safety information should I know at work? Familiarize yourself with the locations of emergency equipment and first aid supplies. Memorize evacuation routes and assembly points. Understand emergency reporting procedures, learn proper operation of fire extinguishers and emergency stops, and recognize the significance of various alarm signals. How does my personal health affect workplace safety? Avoid working while impaired by substances, communicate health conditions that may require accommodations, maintain physical fitness appropriate for your job functions, and ensure adequate rest to maintain alertness and sound judgment during work hours. Frequently asked questions. Employee safety rights. Workers have legal rights to access safety information, report concerns without retaliation, refuse dangerous work, and receive proper training. These rights ensure everyone can work in safe conditions and speak up when problems arise. Essential information about your workplace safety rights with straightforward answers. What safety information am I entitled to? You have the right to access information about workplace hazards, safety protocols, incident reports, and hazardous materials. Your employer must provide safety data sheets for dangerous substances and display clear warning signs in languages workers understand. How should I report safety concerns? You can communicate directly with your employer or through designated safety representatives. These representatives must be allocated time to investigate hazards and participate in safety meetings. Your employer is legally prohibited from retaliating against you for raising safety issues. What options do I have if safety issues remain unresolved? You can contact a safety inspector if your employer's response is inadequate. The inspector must investigate legitimate complaints and can maintain your confidentiality upon request. You or your representative have the right to accompany the inspector during workplace evaluations. Do I have the right to refuse unsafe work? Yes, you can decline work without consequences if you reasonably believe it poses a danger. This includes malfunctioning equipment, missing safety guards, or conditions that could harm your health. Your employer cannot assign others to the task without explaining your safety concerns. What safety training should my employer provide? You should receive comprehensive safety training during paid work hours in a language you comprehend. This includes instruction on safe work practices, emergency procedures, and proper use of safety equipment. You have the right to request additional training if necessary for safe work performance. Is there protection against retaliation for reporting safety issues? Yes, laws prohibit employers from penalizing workers who report safety concerns or participate in safety-related activities. If you experience retaliation, you may be entitled to reinstatement, back pay, and other remedies. What health monitoring should be available for workplace hazards? You have the right to medical examinations related to workplace exposures. These results remain confidential except when disclosure is necessary. If you develop work-related health issues, you may request reassignment to alternative duties without loss of pay. Can I access my workplace health records? Yes, you have the right to review your medical and exposure records maintained by your employer. They must provide prompt access when requested and allow you to make copies. These records are crucial for tracking long-term exposure and potential health effects. Frequently asked questions about National Occupational Safety and Health Advisory Board. The National Occupational Safety and Health Advisory Board is led by the Labor Ministry Secretary and comprises diverse members from government, industry, and safety experts. The board develops safety standards, monitors policies, addresses workplace challenges through specialized committees, and collaborates internationally to promote workplace safety nationwide. Who leads the National Occupational Safety and Health Advisory Board? The Labor Ministry Secretary chairs the board. They oversee all board activities, ensure implementation of decisions, coordinate between stakeholder groups, and represent the board at official functions. The chairperson also plays a key role in establishing national workplace safety priorities. What does the National Board do? The board develops workplace safety regulations, monitors policy implementation, recommends new safety initiatives, and evaluates existing safety measures. Additionally, it conducts assessments of high-risk industries, establishes guidelines for emerging technologies, collaborates with research institutions, and defines safety standards across various industrial sectors. Who are the members of the National Board? The board includes government officials, state representatives, employer and worker delegates, and safety specialists. Specific membership comes from Factory Advisory Services, Mine Safety Administration, Explosives Regulatory Authority, Pollution Control Board, and state government representatives. It also includes designated employer and worker representatives, plus occupational safety experts. Most appointments are for 3-year terms. How often does the board meet? The board convenes quarterly to review safety standards and discuss emerging workplace hazards. These sessions inform policy development and legislative recommendations designed to enhance workplace safety throughout the nation. How does the board handle different workplace challenges? The board establishes specialized committees focused on specific domains such as construction safety, chemical hazards, ergonomics, and workplace mental health. Each committee develops industry-specific guidelines and analyzes incident patterns to identify systematic issues. Does the board work with international organizations? Yes, the board collaborates with global institutions including the International Labour Organization (ILO) and World Health Organization (WHO). These partnerships help align domestic safety standards with international best practices. What kind of reports does the board publish? The board issues annual comprehensive reports containing workplace accident statistics, case studies on hazard prevention, and policy recommendations. These publications serve as valuable resources for legislators, industry leaders, labor unions, and safety professionals. How does the board promote safety awareness? The board organizes national conferences, educational workshops, and public awareness campaigns. These initiatives foster a culture of safety consciousness among employers and workers across all industrial sectors. State Occupational Safety and Health Advisory Board. Frequently asked questions. The State Occupational Safety and Health Advisory Board bridges national safety regulations with local requirements. It comprises diverse stakeholders from government agencies, businesses, labor unions, and safety specialists who collaborate to advise on workplace safety protocols, develop regulations, ensure compliance, and address emerging occupational hazards. Below are comprehensive answers about the State Safety Board's role and functions. What is the State Occupational Safety and Health Advisory Board? This advisory body enhances workplace safety standards within each state. The board serves as a critical link between federal safety regulations and state-specific requirements, ensuring that safety initiatives are tailored to the unique industrial landscape of that jurisdiction. Who serves on the state board? The board features a balanced representation of key stakeholders: government officials and administrators, industry and business representatives, labor union delegates, occupational safety specialists, public health professionals. This diverse composition ensures comprehensive perspectives inform all safety policy decisions. What are the state board's primary responsibilities? The state board's core functions include providing expert consultation to state authorities on safety matters, developing and refining state-specific safety regulations, monitoring workplace compliance with established safety protocols, identifying emerging occupational hazards, recommending practical safety interventions, analyzing workplace incident reports, researching occupation-related illnesses and conditions, evaluating the effectiveness of existing safety measures, proposing regulatory amendments based on field assessments, formulating comprehensive workplace safety improvement strategies. How is the state board structured? Each state determines its board's operational framework, including membership eligibility criteria, required qualifications and expertise, term duration for appointed members, meeting frequency and procedures, decision-making protocols, information dissemination methods. States customize their boards to address regional priorities. The board maintains transparency through published meeting minutes, annual reports, and performance reviews. What role do technical committees play? Technical committees are specialized task forces addressing complex safety challenges. They concentrate on industry-specific safety concerns, conduct detailed workplace environmental assessments, evaluate and validate safety intervention efficacy, provide specialized consultation on technical safety matters. These committees comprise experts in specialized domains such as chemical safety, structural hazards, machinery safeguards, ergonomics, and emergency response planning. Their evidence-based recommendations inform effective regulations and standardized safety protocols. How does the state board coordinate with the national board? The state board maintains strategic alignment with the national board through adapting federal safety standards to address state-specific requirements, submitting quarterly progress and compliance reports, participating in joint strategic planning sessions, exchanging critical data regarding regional challenges and successful interventions. This collaborative approach creates a robust, integrated safety framework that harmonizes national directives with localized implementation. ensuring comprehensive worker protection across all industrial sectors nationwide. Frequently asked questions. Workplace safety rules. Workplace safety rules are government-established standards that all workplaces must follow to prevent injuries and illnesses. These comprehensive regulations address various workplace hazards and can be updated as needed, with states permitted some flexibility to adapt to local conditions. Here are clear answers to common questions about workplace safety rules. What are workplace safety rules? These are essential standards that employers must implement to protect worker health and safety. They help prevent injuries, illnesses, and accidents in the workplace environment. Who establishes these safety rules? The central government develops these regulations in collaboration with safety experts, industry representatives, and worker advocates to create balanced protection measures that safeguard employees effectively. Which workplaces must comply with these rules? All workplaces are required to follow these regulations. This includes manufacturing facilities, construction sites, offices, healthcare institutions, hospitality establishments, and numerous other settings. The government can expand coverage to additional workplace types as necessary. What types of hazards do these rules address? The regulations cover a comprehensive range of workplace hazards. These include excessive noise, hazardous chemicals, biological agents, ergonomic risks, and psychosocial stressors. What do these safety rules encompass? Regulations cover personal protective equipment, medical surveillance, emergency response plans, first aid provisions, safety training programs, and documentation requirements. They are tailored to different industries while maintaining consistent protection for all workers. Can these rules be amended? Yes. The central government may update regulations after receiving recommendations from the National Board and following a 45-day public comment period. Rules may evolve in response to technological advancements or improved safety methodologies. Can states implement their own rules? States may modify regulations to address local needs, provided they obtain prior approval from the central government. This framework allows for regional adaptability while maintaining nationwide consistency and safety standards. How are safety control measures prioritized? Safety controls follow this hierarchy of effectiveness. First priority, eliminate the hazard completely. 1. Second priority, substitute with safer alternatives. Third priority, implement engineering controls. 3. Fourth priority, establish administrative procedures. 4. Last resort, provide personal protective equipment. 5. These regulations are fundamental to creating safer work environments. When properly implemented, they protect workers from harm while promoting operational efficiency and business sustainability. Common questions about workplace safety research. Workplace safety research is conducted by authorized organizations with specialized expertise. These studies evaluate equipment, analyze accidents, and develop safety innovations. The findings inform government regulations and practical safety measures through collaboration between national and state authorities. Below are answers to key questions about how research contributes to workplace safety and protects workers' health and well-being. Who conducts workplace safety research? Authorized organizations including laboratories, universities, and specialized research centers, institutions equipped with advanced tools, and staffed by qualified experts, multidisciplinary teams with specialists in engineering, medicine, and occupational safety organizations like the National Institute of Occupational Health and dedicated departments within technical institutions. What research areas are prioritized? Testing safety equipment effectiveness, investigating workplace accidents, and developing innovative safety protocols, evaluating protective gear, analyzing workplace ergonomics, and reducing exposure to harmful substances, conducting studies in controlled laboratory environments and real-world workplace settings. Emerging focus areas include nanotechnology, workplace stress management, and climate change impacts on worker safety. How does research translate into safer workplaces? Researchers submit evidence-based recommendations to regulatory authorities. Findings contribute to new safety regulations or enhancements to existing standards. All recommendations must be scientifically sound and include implementable guidelines for employers' peer review. Processes ensure the quality and reliability of research findings. Safety interventions follow the hierarchy: hazard elimination, substitution, engineering controls, administrative controls, and personal protective equipment research considers cost effectiveness for businesses of all sizes, especially small enterprises. How is research coordinated between national and state governments? States consult with the National Board before approving research proposals to prevent duplication. Research plans undergo review by the National Board's Scientific Committee. This collaborative approach facilitates knowledge sharing across states. While addressing region-specific workplace issues, the National Board maintains a comprehensive database of all research initiatives to encourage collaboration. Regular conferences bring together researchers from various states to share insights and findings. This systematic research framework continuously advances workplace safety standards. When researchers identify new hazards or improved protection methods, these insights can be rapidly incorporated into safety regulations. This proactive approach not only safeguards workers but also helps businesses reduce costs, prevent accidents, and achieve sustainable growth. Common questions about safety and health surveys. Workplace safety surveys are systematic inspections conducted by authorized officials to identify potential hazards, ensure regulatory compliance, and prevent workplace incidents. These comprehensive surveys involve document examination, equipment assessment, and employee consultation, resulting in safer work environments and enhanced operational efficiency. Below are answers to fundamental questions regarding workplace safety inspections. What are safety and health surveys? Safety surveys are systematic evaluations designed to identify workplace hazards before incidents occur. They ensure organizations maintain compliance with safety regulations established to protect workers. These proactive assessments help prevent accidents, reduce occupational illnesses, and minimize operational costs. Who can conduct these surveys? The following authorized personnel may conduct safety inspections during operational hours: area chief inspectors, factory advice officers, mine safety officers, health services personnel, government authorized inspectors, safety specialists, environmental compliance officers. Do employers receive prior notification about surveys? Yes, in most instances, employers receive formal notification before an inspection. This communication specifies the scheduled date and inspection scope. However, following incidents or in emergency situations, unannounced inspections may occur without prior warning. What must employers provide during surveys? Employers must grant inspectors access to all machinery and equipment, materials for sampling and analysis, safety documentation, all workplace areas, employee training records, personal protective equipment, emergency response protocols. How do workers participate in safety surveys? Workers may be required to undergo health assessments, report observed safety concerns, discuss occupational hazards, provide information about safety training received, demonstrate proper use of protective equipment. Workers may also accompany inspectors during the assessment. They can communicate concerns without fear of reprisal. Time dedicated to these activities is considered work time, and workers must receive appropriate compensation. What follows after a survey? After completion of the inspection, employers receive detailed findings of safety deficiencies. Organizations must address identified issues within specified time frames. Inspectors may conduct follow-up visits to verify corrective actions. Results contribute to the development of enhanced safety protocols. These comprehensive inspections promote safer work environments, reduce injury rates, improve employee satisfaction, and enhance overall organizational performance. Frequently asked questions: statistics collection and migrant worker portal, government systems for collecting workplace safety data, and a comprehensive portal that enables migrant workers to register for benefits, protections, and opportunities as they transition between states for employment. Essential information about workplace safety data collection and the migrant worker registration system. What safety statistics do governments collect? Central and state governments systematically compile data on workplace accidents, injuries, and occupational illnesses. This comprehensive information helps identify industry-specific hazards and inform more effective safety regulations. Researchers and officials utilize this data to implement targeted improvements in workplace safety standards. What is the Migrant Worker Database? This sophisticated online system tracks interstate labor mobility by documenting workers' employment history, skill sets, compensation, and geographic location. The database enables governments to efficiently deliver benefits to migrant workers while monitoring migration trends. Regular updates ensure the system reflects current employment status and relocation patterns. How can migrant workers register themselves? Workers can complete registration on the official portal using their Aadhaar identification. The streamlined form requires minimal documentation, and the website features instructional videos and multilingual telephone support. For workers with literacy challenges, interactive voice response assistance is readily available. Can self-employed migrants also register on the portal? Yes, self-employed individuals who have relocated across state lines are eligible to register. They can document their business category, operational territories, and expansion strategies. This information helps authorities develop targeted support initiatives and connect entrepreneurs with business services and market opportunities. What benefits do registered workers receive? Registered workers gain immediate access to welfare schemes, healthcare services, and financial assistance programs. Benefits maintain continuity as workers relocate between states, eliminating gaps in coverage. Workers receive timely SMS notifications about relevant government initiatives and employment opportunities. Registration confers official recognition, significantly strengthening protections against workplace exploitation and discrimination. How is workers' personal information protected? The portal employs robust security protocols, including access restrictions and advanced data encryption. Workers maintain control over information visibility settings for both government agencies and employers. The system requires administrator authentication and maintains comprehensive access logs for accountability. Regular security audits and vulnerability assessments ensure continued protection of sensitive personal data. Frequently asked questions, safety committees and safety officers. This guide explains workplace safety management structures required by law. Safety committees include both workers and management to identify hazards and improve safety practices. Safety officers are required in larger or high-risk workplaces to implement safety measures and respond to potential dangers. What is a safety committee? A safety committee is a collaborative group comprising representatives from both workforce and management. The government may mandate the formation of these committees based on company size and industry type. Their primary purpose is to ensure workplace safety.
How many people are on a safety committee? Committee size varies according to workplace needs, but worker representatives must equal or outnumber management representatives. This balanced structure ensures workers have an appropriate voice in safety decisions. What does a safety committee do? Identifies potential safety hazards in the workplace, investigates accidents and incidents when they occur, recommends corrective measures for safety issues, improves existing safety protocols, conducts safety training for workers, fosters a safety-oriented workplace culture, monitors effectiveness of safety implementations, assists in emergency response planning. How often does a safety committee meet? Safety committees must convene at least quarterly. They are required to maintain detailed minutes documenting discussed issues, decisions made, implementation timelines, and follow-up verification methods. These records must remain accessible to all workers and authorized officials upon request. When is a safety officer required? Companies must appoint safety officers under these conditions. Establishments with 500 or more workers in factory settings, facilities with 250 or more workers engaged in hazardous manufacturing processes, construction sites employing 250 or more workers, mining operations with 100 or more workers, port facilities and major logistics centers, chemical processing facilities, power generation plants. Other establishments are specified by government regulations. What does a safety officer do? Conducts workplace safety assessments, identifies potential hazards and risks, develops and implements safety training programs, investigates accidents and near-miss incidents, maintains comprehensive safety documentation, ensures compliance with safety regulations, recommends safer work practices and procedures, oversees occupational health programs, liaises with government safety inspectors, evaluates effectiveness of safety measures. What authority does a safety officer have? Safety officers must have direct communication access to senior management. They possess the authority to recommend work stoppage in situations presenting immediate danger to workers. What qualifications must a safety officer have? Educational credentials meeting government specified standards, technical expertise and relevant practical experience, occupational safety and health certification, comprehensive understanding of work processes and associated risks, proficiency in hazard identification and assessment, in-depth knowledge of safety legislation, experience in emergency preparedness planning, strong interpersonal and communication skills, commitment to continuous professional development. How many safety officers are needed? The required number depends on workplace size and risk level. Larger establishments with multiple departments may require specialized safety officers for different operational areas. Health, safety and working conditions. Frequently asked questions. This comprehensive guide addresses critical workplace safety requirements including cleanliness protocols, ventilation systems, temperature management, dust control measures, lighting standards, workspace allocation, and drinking water provisions. Failure to comply with these regulations may result in significant penalties. Essential information about workplace safety regulations under the Occupational Safety, Health and Working Conditions Code. What cleanliness standards must employers maintain? Employers must maintain clean, hygienic workspaces at all times. Floors and common areas require daily cleaning and regular sanitization. Waste materials must be segregated and disposed of according to environmental guidelines. Clean, functional bathrooms must be provided with adequate supplies. Cleaning personnel should follow standardized protocols and schedules. Cleaning chemicals must be stored in designated areas with proper labeling. Accessible hand washing stations with soap and hand drying facilities must be available throughout the workplace. What are the requirements for workplace ventilation and temperature? Workplaces must provide adequate air circulation and maintain comfortable ambient temperatures. Office environments should maintain temperatures between 23 to 26 degrees Celsius with humidity levels of 40-60%. Air conditioning systems require scheduled maintenance and filter replacement. Workers in high temperature environments must receive mandatory rest periods and hydration breaks. Air quality assessments must be conducted quarterly to ensure compliance with safety standards. How should dust and harmful fumes be controlled? Workplaces must be effectively managed to eliminate harmful dust, gases, and chemical fumes. Employers should install appropriate ventilation and extraction systems to remove airborne contaminants. Air quality monitoring must be conducted monthly in high risk areas with documented results. Personal protective equipment must be provided to workers when engineering controls are insufficient. Workers exposed to respiratory hazards require regular health monitoring and medical evaluations. Engineering solutions should be prioritized over reliance on personal protective equipment. What lighting and space requirements apply to workplaces? Workplaces must provide sufficient illumination and adequate space for safe operations. Natural lighting should be maximized whenever architecturally feasible. Office work requires minimum illumination of 500 lux, while precision tasks require higher intensity lighting. Each worker must be allocated a minimum of 3.7 square meters of unobstructed workspace. Emergency exits, pathways, and corridors must remain clear of obstructions at all times. Ergonomic, adjustable furniture should be provided to prevent musculoskeletal disorders. What are the drinking water requirements? Clean, potable drinking water must be available within 30 meters of any workstation. Water quality testing must be conducted monthly with documentation of results. Both ambient and refrigerated drinking water should be provided when feasible. Water dispensers must undergo weekly cleaning and sanitization in high temperature work environments. Employers must provide electrolyte supplements and scheduled hydration breaks to prevent dehydration. What consequences arise from non-compliance with these requirements? Non-compliant employers may face substantial financial penalties, operational restrictions, or facility closure. In severe cases, regulatory authorities conduct periodic unannounced workplace inspections. Employers should implement internal audit processes to ensure continuous compliance. Organizations must establish clear channels for workers to report safety concerns without fear of retaliation. A designated safety officer should be responsible for monitoring compliance with all safety regulations. Sanitation and waste management FAQs. Employers must provide gender-specific sanitary facilities, implement proper waste segregation systems, maintain rigorous cleanliness standards, and conduct systematic facility inspections to ensure workplace health, safety and regulatory compliance. Key questions about workplace sanitation and waste management requirements under occupational safety legislation. What toilet facilities must employers provide? Gender-specific facilities for men, women, and transgender employees. Regularly sanitized and disinfected facilities maintained to high standards. Well ventilated facilities with adequate lighting and secure locking mechanisms. Minimum ratio of 1 toilet per 25 employees. Sanitary disposal units in women's restrooms. Hand washing stations with soap dispensers and hand drying equipment. Custodial staff available throughout all operational shifts. How should workplace waste be managed? Implement waste segregation system for organic waste, recyclables, and hazardous materials. Deploy clearly labeled, color-coded waste receptacles throughout the facility. Treat contaminated water before environmental release. Maintain comprehensive waste disposal documentation. Ensure compliance with local environmental regulations. Conduct periodic water quality assessments. Establish specific protocols for hazardous waste handling. Perform annual waste management system audits. What additional sanitation requirements should employers observe? Stay current with evolving regulatory standards. Utilize advanced waste management technologies when feasible. Conduct biannual staff training on proper sanitation and waste handling procedures. Develop contingency protocols for system failures or accidental spills. Ensure accessibility of all facilities for employees with disabilities. Establish formal channels for reporting sanitation concerns. Designate a dedicated sanitation compliance officer for workplaces exceeding 250 employees. Why are these sanitation standards critical? They safeguard employee health and prevent disease transmission. They minimize environmental impact. They ensure regulatory compliance. They enhance workplace comfort and dignity. They contribute to increased productivity. They mitigate the risk of regulatory penalties. They demonstrate corporate commitment to employee welfare. What inspection schedule should be implemented for sanitation facilities? Daily documented cleaning inspections, weekly infrastructure and equipment assessments, monthly evaluation of cleaning supplies and methodologies, quarterly water quality analysis, annual comprehensive compliance review, immediate inspection following incident reports, random management audits to verify adherence to standards. Adherence to these sanitation and waste management protocols creates a healthier, safer workplace while ensuring compliance with legal requirements. Continuous improvement of systems and methodologies is essential as regulatory frameworks evolve. This slide outlines essential workplace facilities mandated by law, including sanitation areas, food services, healthcare provisions, rest spaces, and child care accommodations. It details both minimum requirements and recommended additional amenities that enhance employee well-being, productivity, and satisfaction, along with potential consequences for non-compliance. Common questions. Workplace facilities. What are workplace facilities and why are they important? Workplace facilities are essential amenities that employers must provide for employee comfort and well-being. They help maintain workforce health and prevent occupational illnesses. They significantly enhance productivity and efficiency. They reduce absenteeism and associated costs. They create a more positive and engaging work environment. What basic facilities must employers provide? Hygienic washing facilities with soap and clean water, gender separated, private shower areas and secure personal storage compartments, appropriate clothing storage and drying facilities, seating accommodation for workers who predominantly stand, adequate lighting and ventilation throughout all work areas, clean, accessible drinking water stations, proper temperature control systems for comfort, effective noise reduction measures, safe, non-slip flooring with clearly marked walkways. Are employers required to provide food services? Workplaces with 100+ employees must provide designated eating areas. These facilities must offer nutritious food options at reasonable prices. They should accommodate various dietary requirements and preferences. What healthcare provisions are Mandatory, fully stocked first aid kits accessible during all operational hours, regular health assessments for employees working with hazardous materials or in high risk environments, designated ambulance rooms in larger workplaces, occupational health centers for work-related medical issues, mental health support resources and programs. What rest facilities must be provided? Separate rest areas for men, women, and transgender employees. Facilities with 50+ workers must provide lunchrooms with adequate seating and tables. Construction sites should offer basic accommodation for workers when necessary. What accommodations are required for employees with children? Workplaces must provide appropriate childcare support. This includes private, hygienic lactation rooms for nursing mothers. What additional amenities do exemplary employers offer? Recreational break areas and relaxation spaces, transportation services for employees living in remote areas, accommodation options for night shift workers, multi-faith prayer and meditation rooms, financial counseling and planning services, comprehensive professional development programs. What are the consequences of non-compliance? Substantial monetary penalties and fines, potential work stoppage or operational shutdowns, legal liability and potential litigation. Regular regulatory inspections ensure facilities meet required standards. Which regulations govern these requirements? The Workplace Safety and Health Code of 2020, International Labor Standards and Conventions, sector-specific regulatory frameworks. How can employees report facility deficiencies? Contact designated welfare officers. In larger organizations, communicate with human resources departments, file reports with relevant government labor authorities. Many organizations implement feedback mechanisms such as surveys and suggestion boxes to identify and address concerns. Childcare at work. Common questions. Workplaces with 50+ employees must provide childcare for children under 6. Options include on-site facilities, partnerships with external providers, or financial subsidies. All childcare centers must employ qualified staff, offer age-appropriate equipment, and undergo regular safety inspections. Below are comprehensive answers to frequently asked questions about employer-mandated childcare provisions under workplace safety regulations. Which workplaces need to provide childcare? Any workplace employing more than 50 workers must provide childcare services for children under 6 years of age. This regulation applies across all industries and sectors. Both full-time employees and contract workers are counted toward this threshold. Where should the childcare be located? Childcare facilities should be situated within 500 meters of the workplace or in a location accessible enough for mothers to visit during break periods. The facility should be positioned away from excessive noise and potential hazards, ideally on the ground floor with access to outdoor play areas. Can companies use other childcare options? Yes. Companies have several alternative compliance options, utilizing existing government or private childcare centers, establishing partnerships with childcare service providers, developing shared childcare arrangements with neighboring companies, providing subsidies to help employees access quality childcare nearby, collaborating with specialized childcare organizations to establish suitable facilities. What staff should work at workplace childcare? Compliant childcare centers must employ professionally trained childcare specialists, sufficient staff to maintain appropriate child-to-caregiver ratios, at least one certified first aid responder on site at all times, supervisors with qualifications in early childhood education, dedicated personnel for maintenance and food preparation. All staff members must undergo thorough background screening and health assessments. What should workplace childcare facilities provide? Every childcare center must be equipped with age-appropriate educational toys and developmental resources, hygienic sleeping arrangements for rest periods, proper ventilation and natural lighting, child-sized bathroom fixtures and dedicated changing stations, distinct areas for infants and older children, nutritious meals prepared in sanitary kitchen facilities, protected outdoor recreation areas with adequate shade, privacy, compliant security monitoring systems, clearly marked emergency exits and safety equipment. How are these childcare centers monitored? Childcare facilities undergo monitoring through scheduled and unannounced inspections by safety authorities, assessment visits by early childhood education specialists, comprehensive attendance documentation, quarterly safety compliance evaluations, annual permit renewal processes, structured Parental feedback mechanisms. Oversight committees comprising company representatives, employee delegates, and child care experts. Quality child care provisions enable employees to better balance professional responsibilities with family obligations. Such initiatives demonstrate an employer's commitments to supporting their workforce while ensuring regulatory compliance. Regular communication between parents and child care professionals facilitates continuous improvement of these essential services. Frequently asked questions. Working hours. Workers are entitled to an 8-hour workday, a 6-day work week with 1 mandatory rest day, and double pay for overtime. Employers must comply with these regulations or face significant penalties. Clear explanations about working hour regulations under the Labor Code. How many hours can I work in a day? The maximum is 8 hours per day. This includes all time spent at the workplace except for breaks longer than 30 minutes. How many days can I work per week? You cannot be required to work more than 6 days in a week. You are entitled to at least 1 day off every week. How much rest time do I get each week? You must receive a minimum of 24 consecutive hours, 1 full day, of uninterrupted rest each week. This typically falls on Sunday, but employers may designate another day with proper advance notice. How much should I get paid for extra work? You are entitled to double your regular pay rate for any overtime hours. Overtime work must generally be voluntary except in emergency situations. Can my employer require me to work on my rest day? Generally, no. If you voluntarily work on your designated rest day, you must receive premium pay and be granted an alternative rest day within 3 working days. Are there special rules for night workers? Yes. Employers must provide safe transportation home for employees working extended hours at night. Additionally, there are restrictions on consecutive night shifts to protect worker health. How will I know my work schedule? Your employer is required to post work schedules, break periods, and weekly rest days in a visible location accessible to all employees. What if my employer violates these regulations? You can file a confidential complaint with the labor authority without fear of retaliation. Employers who violate these regulations may face monetary fines, administrative penalties, or potential suspension of business licenses. These regulations apply to all businesses unless specifically exempted. They are designed to safeguard your health and ensure adequate rest periods. Note that modified regulations may apply to healthcare workers, transportation services, and emergency response personnel. Special rules for different types of workers. Different industries have specific regulations for working hours, rest periods, and safety measures tailored to the unique challenges of each profession. Clear explanations of regulations for specialized occupations. Underground mine workers working hours. Maximum 6 hours daily or 36 hours weekly, as mandated by government regulations. Rest requirements. Minimum 12 consecutive hours of rest between shifts. Safety protections. Requirements include proper ventilation, semi-annual health examinations, essential safety equipment, helmets, respirators, reinforced footwear, quarterly emergency response training, and prohibition on solitary work in hazardous zones. Transport workers' work time definition includes driving, traffic delays, documentation, supervision of loading/unloading, vehicle maintenance, repair waiting periods, and required training. Driving limits. Standard 8-hour daily maximum, extendable to 10 hours in exceptional circumstances. Mandatory 30-minute break after 5 consecutive driving hours. Rest periods, weekly minimum of 36 consecutive rest hours including Sunday, with prohibition on more than 4 continuous nighttime driving hours without breaks. Journalists' working hours, maximum 144 hours per 4-week period, with guaranteed weekly minimum rest of 24 hours. Leave entitlements, 1 month of paid annual leave per year of service. Special protections. Rights include editorial independence, protection against unjustified termination, legal assistance for work-related issues, hazard insurance for dangerous assignments, and source confidentiality. Factory workers' working hours, maximum 48 weekly hours with daily limit of 9 hours under normal conditions. Overtime compensated at double the standard rate. Safety rights. Workers may refuse unsafe work without penalty. Employers must provide adequate ventilation, dust control, proper illumination, clean drinking water, sanitary facilities, and noise protection, vulnerable worker protections, employment prohibited for children under 14, hazardous work restricted for adolescents, special accommodations required for pregnant workers and new mothers. Annual paid leave. Workers who have completed 180 days of service are entitled to annual paid leave. The amount varies based on job type, with provisions for carrying over, cashing out, or transferring unused leave. Employers must respond to leave requests within 15 days. Under workplace safety law, employees are entitled to paid time off. Below are answers to common questions about your leave entitlements. Frequently asked questions: who qualifies for annual paid leave? Any employee who has completed at least 180 days of service within a year. These qualifying days include regular work days, paid time off, workplace injury leave, maternity leave, paid work stoppages, and training days. How is paid leave calculated? Regular workers, 1 day of leave for every 20 days worked. Young workers and mine workers, 1 day of leave for every 15 days worked. Workers in hazardous occupations, 1 day of leave for every 15 days worked. Any fraction of a day equal to or greater than half counts as a full day. Sundays and public holidays during your leave period are not deducted from your leave balance. What options exist for unused leave? You may carry forward up to 30 days of unused leave to the following year. If your employer denies your leave request, those days can be carried forward without limitation. You may also take up to 30 accumulated leave days consecutively. What is the leave application process? Submit a leave request to your employer, who must respond within 15 days. If your request is denied, your employer must provide written justification based on business requirements. Employers are required to maintain records of all leave requests and responses. Can leave be converted to payment? Yes. Unused leave can be converted to payment at year-end or upon termination of employment. The payment calculation includes your daily wage plus allowances, excluding travel allowances, and regular overtime. Payment must be processed within 30 days. Is it possible to cash out leave during employment? With employer approval, you may convert some leave to payment during the year, particularly for urgent situations such as medical expenses or educational costs. What happens to accrued leave benefits upon death? Leave payments will be directed to your designated beneficiary or to the family member who is your legal heir. These leave provisions ensure workers receive adequate rest periods while maintaining financial stability. Employers are required to display these leave regulations at the workplace in the local language. Record keeping requirements. Common questions: employers must maintain detailed worker records for at least 3 years. Display important workplace information through signs. Provide comprehensive pay slips, and submit regular reports to inspectors. Proper record keeping demonstrates compliance and provides essential documentation during disputes or inspections. The following questions address essential record keeping requirements that employers must fulfill under occupational safety and health legislation. What worker records must employers keep? Employers must maintain comprehensive records, either physical or digital, of specific job responsibilities for each employee, working hours, including overtime, rest days and official holidays, wages, bonuses, and all forms of compensation, all categories of leave, sick, annual, maternity, employment history and career progression, personal information and emergency contact details, training records and certifications, medical examinations and fitness certificates, workplace accidents and medical treatment provided. How long should records be kept? All records must be retained for a minimum of 3 years from the date of the last entry. Hazardous industries may require extended retention periods. Records must remain accessible for inspection during business hours. What information must be displayed at workplaces? Employers must prominently display notices that include summary of applicable legislation in local languages, inspector's name, address, and contact information, working hours and shift schedules, wage payment dates and methods, safety protocols and emergency procedures, names of safety officers and first aid providers, location of medical facilities, works committee information, grievance submission procedures, calendar of holidays. When should workplace notices be updated? Notices must be updated promptly following changes in management, working conditions, or safety protocols. All notices should be legible, clearly visible, and positioned at eye level. What information must be included in pay slips? Employers must issue pay slips, physical or electronic, at least 1 day before wage disbursement. These documents should clearly itemize the full compensation and all deductions. What reports must employers submit to inspectors? Employers are required to regularly submit monthly wage and deduction statements, annual employment statistics, accident reports within 24 hours of occurrence, quarterly compliance reports, annual structural safety assessments, annual health examination reports for hazardous occupations, air and water quality monitoring reports, safety equipment inspection certificates, training documentation. What are the consequences of inadequate record keeping? Failure to maintain proper records may result in financial penalties or imprisonment for repeated violations. Electronic records must incorporate backup systems and comply with data protection regulations. Why is effective record keeping important? Diligent record keeping demonstrates regulatory compliance, facilitates resolution of disputes, provides evidence during inspections, helps identify workplace issues, supports legal defense when necessary, facilitates smooth management transitions. Frequently asked questions. Inspector-cum-facilitators. Inspector-cum-facilitators are government officials responsible for enforcing labor laws and ensuring workplace safety compliance. They are appointed based on specific qualifications, operate in designated geographic or industry-specific jurisdictions, and conduct systematic inspections using computerized allocation systems to ensure fairness. The inspection framework follows a hierarchical structure from chief inspectors to assistant inspectors. These questions explain the role and functioning of inspector-cum-facilitators under the Occupational Safety, Health and Working Conditions Code. Who are inspector-cum-facilitators? They are authorized government officials who monitor workplace compliance with labor laws. They conduct site inspections, provide remediation guidance, and ensure worker safety and fair treatment standards are maintained. How are inspector-cum-facilitators appointed? They are appointed by the government based on specific qualifications and professional experience. Standard requirements include 5-7 years of experience in labor related sectors, a degree in law or industrial relations, specialized knowledge of occupational safety standards, demonstrated integrity and ethical conduct. Appointees undergo comprehensive initial training before field deployment and participate in mandatory periodic refresher programs. Where do inspector-cum-facilitators work? They operate within government-designated jurisdictions. Some are assigned to specific districts or industrial zones, while others may cover entire states. Certain inspectors specialize in particular industries based on their expertise. Urban deployments typically focus on concentrated industrial areas. Rural assignments often encompass broader geographical regions with dispersed business operations. Jurisdictional boundaries are periodically adjusted to accommodate industrial development patterns. How are inspections conducted? Modern inspection protocols utilize computerized systems that generate randomized establishment selection for inspection, assign inspectors through algorithm-based allocation to eliminate bias, implement risk-based prioritization for higher risk operations, provide digital platforms for documentation submission, maintain comprehensive records of findings and subsequent compliance measures. This systematic approach enhances transparency and fairness while minimizing unnecessary business disruption. What is the organizational structure of the inspection system? The inspection framework operates through a defined hierarchy. Chief Inspector-cum-facilitator provides strategic direction and intergovernmental coordination. Additional and joint chief inspectors oversee specialized divisions focusing on areas like occupational health or structural safety. Deputy chiefs manage regional operations and field team coordination. Senior inspectors provide mentorship to junior staff and handle complex compliance cases. Assistant inspectors conduct routine inspections and implement awareness initiatives. This hierarchical structure ensures consistent enforcement practices while offering progressive career advancement opportunities for inspection personnel. Powers of inspector-cum-facilitators. Frequently asked questions. Inspector-cum-facilitators possess comprehensive authority to access workplaces, inspect facilities, examine documentation, investigate incidents, obtain samples, mandate safety enhancements, and require health assessments. They must uphold confidentiality while thoroughly documenting their findings and frequently collaborate with other regulatory bodies to ensure comprehensive compliance. What premises can inspectors access and during what hours? Inspectors are authorized to enter any workplace during reasonable hours, day or night. They have the authority to conduct unannounced inspections during operational hours. Their jurisdiction extends to worker accommodations provided by employers. What aspects of a workplace can inspectors evaluate? Inspectors are empowered to assess buildings, machinery, equipment, and materials for compliance with safety regulations. They may take measurements, capture photographs, or create recordings to document safety concerns. Their authority includes examining digital records relevant to worker safety protocols. What authority do inspectors have when investigating incidents? Inspectors are authorized to investigate accidents or hazardous conditions thoroughly. They may interview affected workers and witnesses confidentially, without management present. Following serious incidents, they can conduct comprehensive investigations, gather evidence, and interview all relevant parties. What documentation can inspectors request from employers? Inspectors have the authority to demand access to registers, records, and any pertinent documentation. They may duplicate materials, particularly records that demonstrate compliance violations. Their examination extends to employment and compensation records to verify adherence to labor regulations. What technical assessments can inspectors conduct? Inspectors may collect samples of materials, substances, or air quality for laboratories analysis. They are authorized to inspect any potentially hazardous equipment or machinery. Their evaluation includes testing safety mechanism functionality and reviewing structural and equipment designs. Can inspectors mandate corrective actions for safety violations? Inspectors are empowered to issue formal notices specifying required remedial actions and compliance deadlines. For critical hazards, they can demand immediate corrective measures. In cases of imminent danger, they possess the authority to hold operations entirely. They may restrict access to areas or equipment where serious violations are identified. Can inspectors require health assessments for workers? Inspectors have the authority to mandate medical examinations for workers exposed to hazardous substances. These assessments serve to identify potential occupational health impacts. Are inspectors bound by confidentiality requirements? Inspectors must maintain strict confidentiality regarding sensitive business information acquired during inspections. Simultaneously, they must uphold transparency in their enforcement methodologies. How do inspectors document their findings? Inspectors are required to meticulously document all observations and enforcement actions in official reports. These comprehensive reports are submitted to appropriate authorities to ensure proper follow-up on safety concerns. Do inspectors coordinate with other regulatory entities? Inspectors regularly collaborate with other regulatory agencies on joint investigations. This coordination enhances efficiency when multiple regulatory frameworks apply to a single workplace. Special powers for hazardous workplaces. Frequently asked questions. Inspectors possess comprehensive emergency authority to suspend operations, evacuate personnel, and implement immediate safety protocols in hazardous workplace environments. These regulatory powers are tailored to specific industries including manufacturing, mining, maritime operations, and construction. While employers retain appeal rights, the paramount concern remains worker safety and accident prevention. Below are frequently asked questions regarding inspectors' emergency authority in hazardous workplace environments. What special powers do inspectors have in hazardous workplaces? Inspectors are authorized to halt operations, evacuate personnel, decommission equipment, and mandate immediate safety corrections upon identifying hazardous conditions. These interventions are designed to prevent workplace accidents and protect employee well-being. The scope and nature of these powers vary according to industry-specific regulations. What can inspectors do in dangerous factories? Prohibit worker access to areas presenting imminent hazards. Order immediate evacuation of high-risk zones. Decommission unsafe machinery pending certified repairs. Isolate dangerous equipment or operational areas. Establish mandatory safety protocols before operations can resume. Mandate atmospheric testing in confined spaces. Require independent safety certification before restarting operations, order improvements to ventilation, illumination, or emergency egress, mandate proper removal and storage of hazardous materials. What powers do inspectors have in mind? Issue compliance notices specifying required safety enhancements, suspend operations for regulatory non-compliance, restrict access to compromised areas of the mining facility, halt specific mining activities pending safety review, mandate additional safety equipment and protective measures, require procedural modifications for high-risk operations, order installation of emergency supports in unstable excavations, require enhanced gas monitoring protocols in underground operations, mandate improved emergency response systems and protocols, suspend blasting operations pending safety procedure verification. How can inspectors protect dock workers? Suspend port operations during hazardous conditions, prohibit loading unloading activities during adverse weather, restrict use of non-compliant lifting equipment, mandate enhanced safety protocols for hazardous cargo, order evacuation when structural integrity is compromised, enforce proper segregation of dangerous materials, require specialized training for hazardous materials handling, mandate installation of fall protection along waterfront areas, enforce safe container stacking and securing protocols. What special powers apply at construction sites? Halt elevated work when fall protection systems are inadequate, mandate structural reinforcements for unstable constructions, require additional safety training before work resumption, specify mandatory personal protective equipment, order installation of shoring and excavations and trenching operations, verify proper certification for crane and heavy equipment operators, mandate enhanced safeguards around electrical hazards, require comprehensive emergency evacuation procedures. Can employers challenge these decisions? Yes. Employers may appeal work stoppage orders through established administrative channels. However, compliance with safety directives remains mandatory during the appeal process to ensure worker protection. Inspectors must provide detailed written documentation of identified hazards and required remedial actions. What is the main goal of these special powers? The primary objective is preventative safety and worker protection rather than punitive action against employers. In situations presenting immediate life-threatening conditions, inspectors are also authorized to coordinate with emergency services and facilitate evacuations. All interventions must be proportionate to the level of risk identified, with worker safety remaining the overriding priority. Frequently asked questions about confidentiality. Confidentiality protocols safeguard sensitive workplace information, proprietary trade secrets, and whistleblower identities. Officials must maintain absolute discretion throughout their lifetime, with rigorous procedures for information handling and storage. Violations may result in severe penalties, including termination and legal action. Below are common questions regarding the proper handling of confidential information. What information must be kept confidential? All workplace records obtained during official duties must remain confidential. This encompasses manufacturing processes, trade secrets, and proprietary business information gathered during inspections. Protected information includes formulas, equipment configurations, operational methodologies, and strategic business plans. How long does the confidentiality obligation last? Officials must maintain confidentiality even after their employment with the department ends. This obligation continues throughout their lifetime to ensure long-term protection of sensitive information. What security measures should be implemented for confidential records? Implement robust security protocols, including encryption for digital files and secured storage containers for physical documents. Maintain comprehensive access logs when transferring files between authorized personnel. Conduct regular security audits to detect potential unauthorized access. Who is authorized to access confidential information? Confidential information may only be shared with courts during relevant legal proceedings. Official committees established under this code direct supervisors with legitimate need to know status officials processing worker compensation claims, the Indian Bureau of Mines for relevant mining matters, government agencies with proper authorization, medical professionals treating occupation-related illnesses, researchers with personally identifiable information redacted. What protocols govern the sharing of confidential information? Disclose only information essential for executing official responsibilities. Maintain detailed documentation of all disclosures, including content, date, recipient, and justification whenever feasible. Utilize anonymized data rather than information that could identify specific individuals or businesses. How are whistleblowers protected? Inspectors are prohibited from revealing complainant identities without explicit written consent. When conducting inspections in response to complaints, they must not indicate that the visit was complaint-driven. These measures safeguard workers from potential retaliation for reporting violations. What are the consequences for confidentiality breaches? Violations of confidentiality protocols may result in disciplinary action, including termination, professional sanctions, and potential criminal charges for breaching privacy legislation. What special protections exist for vulnerable workers who report violations? Enhanced protective measures are implemented for complaints from vulnerable workers. Strategies may include conducting simultaneous inspections at multiple locations to obscure the specific site that generated a complaint. Secure, anonymous reporting mechanisms are provided to prevent identification of individual reporters. Why are these confidentiality measures critical? These protocols are fundamental to maintaining workplace safety and compliance. Without robust confidentiality protections, critical information about hazardous conditions might remain unreported due to fear of reprisal, potentially compromising worker safety and public health. Frequently asked questions. Medical officers are government-appointed physicians with occupational health expertise who conduct health assessments, maintain comprehensive records, deliver emergency care, and submit detailed reports. They must disclose potential conflicts of interest and possess specific qualifications essential for safeguarding worker health. Essential information about medical officers in workplace settings. Who are medical officers and how are they appointed? Medical officers are physicians appointed by the government to serve in factories, mines, and other industrial settings. They must possess specialized training in occupational health. The government thoroughly evaluates their qualifications and professional experience before appointment. They may serve in full-time or part-time capacities depending on workplace requirements. Why must medical officers disclose their interests in the workplace? Medical officers are required to disclose any potential conflicts of interest related to their workplace. This includes stock ownership, family connections in management positions, or previous employment relationships. This transparency ensures impartial decision-making. Failure to disclose such information may result in termination of appointment. What are the main duties of medical officers? Medical officers fulfill several critical responsibilities, including assessing fitness to work for employees in hazardous positions, determining occupational origins of illnesses, evaluating young workers' capacity for safe employment, maintaining comprehensive health documentation for all personnel, conducting periodic health examinations, providing safety recommendations to management, investigating unusual patterns of workplace illness, delivering emergency medical response following incidents, developing and training first aid response teams, educating workers about occupational health hazards. What reports must medical officers submit? Medical officers are required to prepare and submit regular reports covering comprehensive workforce health status, workplace disease outbreaks or clusters, recommendations for safety improvements, compliance with occupational health regulations, statistical analysis of workplace injuries, effectiveness of health intervention programs, utilization of medical facilities and resources, health considerations for vulnerable worker populations, progress on previously identified health concerns, emerging occupational health risks requiring attention. These reports must be submitted quarterly, with immediate notification required for urgent matters. These documents may be reviewed during regulatory inspections and utilized for analyzing health trends across industrial sectors. Women's employment. Frequently asked questions. Women have equal rights to all employment opportunities, including night shifts with adequate safety measures. Special protections exist for hazardous work and pregnancy. Employers must maintain detailed records and establish complaint mechanisms for workplace issues. Clear answers to common questions about women's workplace rights under this code. What employment rights do women have? Women are entitled to work in all job categories and workplace environments. Employers cannot discriminate based on gender during hiring. Equal pay for equal work is mandatory, and women must have the same career advancement opportunities as men. These provisions eliminate traditional barriers in factories, mines, and technical positions. Are women permitted to work night shifts? Yes. Women may work between 7 p.m. and 6 a.m. with their consent. Employers must obtain written permission for night work. Women cannot face termination or penalties for declining night shifts. What safety measures are required for women working night shifts? Employers must provide secure transportation with GPS tracking and vetted drivers, adequate lighting, security personnel, including at least one female guard when 20+ women are employed, emergency response systems, and appropriate rest breaks. Regular safety audits must be conducted and documented. How are women protected in hazardous occupations? Before women can engage in hazardous work, employers must implement safety protocols including regular health assessments, quarterly for chemical or radiation exposure, gender-appropriate safety equipment, exposure limits for harmful substances, and comprehensive safety training. What accommodations exist for pregnant women in hazardous workplaces? Pregnant women have the right to request transfers to safer positions. Employers should accommodate these requests to safeguard both maternal and fetal health. What documentation must employers maintain regarding women workers? Employers must keep records of equitable hiring policies, workforce diversity statistics, for establishments with 50+ employees, written night shift authorizations, safety protocols for hazardous work, and regular safety inspection reports. These records must be available for official inspection upon request. What channels exist for women to report workplace concerns? Employers must establish grievance mechanisms, particularly regarding night shift issues. Women must be able to report concerns without fear of retaliation. A committee comprising management representatives, safety officers, and women workers should conduct regular reviews of safety measures. Frequently asked questions on contract labor. Contract labor rules apply to businesses using 50+ contract workers. Contractors must obtain licenses. Employers must provide essential facilities. Wages must be paid promptly through banking channels, and both parties face penalties for violations. Contract workers are entitled to social security benefits comparable to regular employees. Here are straightforward answers to common questions about contract labor regulations for both employers and workers. What businesses need to follow these contract labor rules? These regulations apply to businesses employing 50 or more contract workers and to contractors who provide 50 or more workers. The government reserves the right to adjust this threshold as necessary. Certain government departments may receive exemptions. Businesses operating across multiple states should register with central authorities, while those operating within a single state register with state authorities. Do contractors need a license to provide workers? Yes. Contractors must obtain a government license to supply workers. This license remains valid for 5 years and is renewable. To acquire a license, contractors must submit a security deposit and provide comprehensive details about their business operations and worker management practices. The government has authority to reject applications or cancel existing licenses if regulations aren't followed. What must employers provide for contract workers? The principal employer, not just the contractor, must ensure basic facilities including dining areas, restrooms, clean drinking water, first aid services, and adequate housing. Failure to provide these amenities can result in financial penalties. Some employers may also be required to offer transportation services, childcare facilities for children of female workers, and skills development programs. How should contract workers be paid? Contractors must ensure timely wage payments through banks or electronic transfer systems. Unauthorized deductions are prohibited. If a contractor fails to pay wages on time, the principal employer becomes responsible for worker payments. All transactions must be properly documented. Wages must comply with minimum wage legislation and include additional compensation for overtime work. What happens if someone breaks these rules? Both the principal employer and contractor may face substantial fines and potential suspension of operating licenses. Labor officials have authority to conduct workplace inspections to verify compliance. Employers must maintain comprehensive records of all contractors, workers, work assignments, and payment transactions. What benefits should contract workers receive? Contract workers are entitled to Social Security benefits including retirement savings, Provident Fund, insurance coverage, and gratuity payments upon completion of service, where applicable. These provisions help ensure contract workers receive protections similar to those enjoyed by permanent employees. FAQs, core activities and contract labor. Clear explanations about regulations governing contract workers for primary business operations under the 2020 Industrial Relations Code. Contract workers typically cannot be employed for core business activities, primary functions that generate revenue or require specialized knowledge, though exceptions exist for seasonal work, specialized expertise, or temporary requirements. Organizations must maintain accurate documentation and may face significant penalties for non-compliance. What are core activities in a business? Core activities represent the essential operations of a business, including primary business functions or production processes, operations critical to business continuity, activities directly generating revenue, services impacting product quality or customer experience, work requiring specialized industry knowledge, functions involving confidential information. Can businesses hire contract workers for core activities? Generally, no. Legislation prohibits businesses from engaging contract workers for core activities. This regulation safeguards workers' rights and ensures job security for essential functions. What consequences might businesses face for non-compliance? Organizations violating these regulations may face substantial financial penalties, potential criminal proceedings, revocation of business licenses for repeated violations. Contract workers establishing claims as regular employees. Are there exceptions when contract workers can perform core activities? Yes. Contract workers may perform core activities when such arrangements are standard practice in comparable industries. The work requires less than half a workday. There is an unexpected surge in workload. The task requires specialized equipment or expertise unavailable in-house. The work is seasonal or intermittent. The activity supports core functions without being essential. The position requires specialized skills for a limited duration. The organization is transitioning its operations or technology. What documentation should employers maintain regarding contract workers? Employers should maintain justifications for engaging contract workers for potentially core activities, workforce planning documentation, operational assessment reports, evidence demonstrating applicable exceptions. How are disputes about core activity classification resolved? The dispute resolution process follows these steps. The concerned party submits evidence to government authorities. The government may establish a committee for investigation. The committee consults management, workers, and domain experts. They may conduct workplace inspections. Workers performing the disputed activities may be interviewed. The committee examines comparable industry practices. The government issues a determination within 90 days. This decision is binding unless legally challenged. Appeals must be submitted within 30 days. What compliance measures should businesses implement? Businesses should periodically review their contract labor arrangements, thoroughly document justifications for contract worker engagement, establish policies clearly defining core and non-core activities, update these definitions as business operations evolve, consult labor law specialists regularly, maintain transparency with authorities during investigations. What is the rationale behind limiting contract labor in core activities? These limitations aim to prevent worker exploitation, ensure employment security for essential functions, maintain quality standards in critical operations, balance organizational flexibility with worker protections, promote equitable employment practices. Frequently asked questions. Interstate migrant workers. These regulations protect workers who relocate between states, apply to workplaces employing 10+ migrant workers, require employers to provide safe conditions and travel benefits, and ensure migrant workers receive equal benefits as local workers. Clear explanations about regulations for workers who relocate between states under the 2020 Safety, Health and Working Conditions Code. Which workplaces follow these regulations? These regulations apply to all workplaces, government and private, that employ 10 or more workers from other states. This includes factories, construction sites, farms, mines, service companies, and establishments with seasonal work. The threshold of 10 workers is calculated based on any single day in the previous 12 months. Who qualifies as an interstate migrant worker? An interstate migrant worker is someone who was recruited in one state to work in another state, migrated independently from one state and secured employment in another state, earns up to $18,000 per month, performs temporary or seasonal employment, is properly registered in the system. The updated regulations now protect self-migrating workers, not just those hired through contractors. What are employers' obligations toward migrant workers? Employers must provide safe working conditions, adequate housing and sanitation facilities, report fatalities to authorities in both states within 48 hours, extend all benefits such as health insurance and pension available to local workers, maintain comprehensive records of all migrant workers, issue passbooks documenting employment periods and wage rates, designate a liaison officer if they employ 100 or more migrant workers, supply safety equipment, first aid facilities, health checkups, and childcare when necessary, display notices in workers' languages informing them of their rights. Employers violating these regulations face fines ranging from $50,000 to $1,000 and or imprisonment up to 1 year. What travel benefits must employers provide? Employers must provide an annual travel allowance that includes reimbursement for round-trip travel to the worker's hometown by train, sleeper class, or bus, meal allowance during the journey, paid leave while traveling, prorated payment for employment periods less than a year. This allowance must be disbursed before travel commences. If public transportation is unavailable, employers must arrange alternative transport. Workers may utilize this allowance even if traveling to destinations other than their hometown. Employers cannot deduct this allowance from wages. Why are these protections necessary? These protections address unique challenges faced by migrant workers, including separation from home and family, language barriers, unfamiliarity with local systems and regulations, vulnerability to exploitation. Migrant workers contribute significantly to the economy, and these regulations ensure they receive fair treatment while working away from their home states. Frequently asked questions. Welfare schemes for migrant workers. Key welfare schemes include food benefits through One Nation One Ration Card, construction worker benefits, insurance, education, pension, simplified registration processes, multilingual helplines for assistance, and ongoing government research to improve services. What food benefits are available for migrant workers? Migrant workers can access subsidized food items including rice, wheat, and sugar through the One Nation One Ration Card system. You can use your ration card in any state, not just your home state. Visit any fair price shop in India and verify your identity with your fingerprint to receive food benefits. Most shops are equipped with auto verification machines. Special registration camps are often organized at work sites to help you enroll in the program. What benefits can migrant construction workers receive? Construction workers are eligible for benefits including accident insurance, health coverage, educational assistance for children, maternity benefits, and pension plans. These benefits are portable across different states. Benefits include up to $50,000 for emergency medical care, $1,000 monthly pension after age 60, and $515,000 annually for children's education. Women can receive $6,000 maternity benefit for up to 2 births. How do I register for construction worker benefits? You must provide proof of at least 90 days of construction work in the past year. Dedicated teams visit major construction sites to facilitate registration. Many states offer user-friendly mobile applications for easy registration. Approximately 35 million construction workers are currently registered across India. Is there a helpline I can call if I need assistance? Yes. Toll-free helplines are available 24/7 for your support. These helplines provide assistance in 12 major Indian languages, guidance on accessing welfare benefits, support for filing complaints, legal assistance and emergency support, connections to government offices and support organizations, mental health support services. Each call receives a tracking number allowing you to monitor your issue until resolution. In areas with high migrant populations, support teams can respond within 6 hours.
is the government learning about migrant workers' needs? The government conducts research on migration patterns, employment sectors, skill levels, and challenges faced by migrant workers. These studies inform better policy planning and program development. The Labor Ministry allocates 25 crores annually for this research. Researchers track 50,000 migrant families across 12 states to study the long-term impacts of migration on families. Special focus is given to women, children, and workers in hazardous occupations. Research findings are applied to improve services for migrant workers. Audiovisual workers. Frequently asked questions: audiovisual workers in film, television, and digital media must have registered written agreements that clearly outline work details, compensation, and rights. Special provisions apply to international projects and child performers, with strict emphasis on safety measures and proper documentation. Who is considered an audiovisual worker? An audiovisual worker is anyone employed in the creation of movies, television shows, advertisements, animations, or digital content. This category encompasses actors, directors, camera operators, sound technicians, lighting crews, costume designers, makeup artists, editors, and all supporting production staff. What productions qualify as audiovisual work? Audiovisual productions include feature films, television programs, talk shows, sports broadcasts, commercials, cartoons, animations, and online content. The definition extends to emerging formats, such as virtual reality experiences, streaming series, video podcasts, and artificial intelligence-driven projects. What requirements must I fulfill to work as an audiovisual professional? To work legally in this industry, you must secure a written agreement with your employer. Ensure this agreement is properly registered with government authorities. Maintain a personal copy for your records and protection. What is the time frame for registering my work agreement? You must register your agreement within 30 days of signing. Be aware that unregistered agreements may be deemed invalid, potentially jeopardizing your access to benefits and protections. Are short-term assignments exempt from formal agreements? No. Even assignments lasting fewer than 7 days require a formal agreement. While expedited registration processes may exist for brief engagements, a proper agreement remains mandatory. What essential elements should my work agreement contain? Your agreement must explicitly outline specific duties and responsibilities, compensation structure and benefits, including provident fund provisions where applicable, working hours and schedule, safety protocols and measures available, welfare facilities, dispute resolution procedures, payment timeline and methods, leave entitlements, overtime compensation policies. What additional provisions apply to international projects? For international projects, your agreement must comply with both Indian regulations and relevant international standards. Specify which country's legal framework governs your employment. Clearly state your payment currency. Include proper work permits and documentation if you're a foreign national. How does digital technology factor into modern agreements? Contemporary agreements now recognize digital signatures that comply with electronic signature laws. Modern contracts typically address content rights across multiple platforms, streaming royalty structures, and appropriate crediting across various distribution channels. What special protections exist for child performers? Agreements involving child performers must include comprehensive educational arrangements during production, strictly enforce limitations on working hours, mandatory presence of a parent or guardian, enhanced protections that fully comply with child labor legislation. What safety and welfare provisions should my agreement include? Your agreement should specify workplace accident insurance coverage, transportation and accommodation arrangements for location shoots, comprehensive safety protocols for high-risk filming activities, clear anti-harassment policies and reporting procedures, specialized training requirements for technical positions. Mine management. Frequently asked questions. Mine management involves safely operating mining facilities through qualified leadership, clear communication and adherence to safety protocols. Proper management requires certified managers with specific qualifications who oversee all operations and safety measures. Here are common questions and answers about mine management explained in clear terms. What is mine management? Mine management encompasses the comprehensive oversight of mining operations, ensuring workplace safety, regulatory compliance, proper resource extraction, and environmental protection. Effective management prevents accidents, optimizes productivity, and ensures legal compliance. Who is a sole manager in mining? A sole manager is the primary authority responsible for mine operations. They must possess proper certification and extensive mining expertise, including specialized mining education and 5-10 years of practical experience. No mine can operate without a manager for more than 14 days, and qualified personnel must assume responsibilities during the manager's absence. What are a mine manager's responsibilities? Mine managers oversee all operational aspects of the mine, ensuring safety compliance, regulatory adherence, and efficient workflow. Their authority includes issuing directives, conducting inspections, and maintaining comprehensive safety documentation. They must develop contingency plans for emergencies such as fires, floods, or structural collapses, while also managing budgets and resource allocation. How should communication work in a mine? Communication must flow through the mine manager from ownership, except during emergencies, establishing a clear chain of command and preventing miscommunication. All communications should be documented. Daily briefings are essential for sharing critical information, and regular safety meetings with all personnel should address concerns and promote safe working practices. Why is proper mine management important? Effective mine management is crucial for preventing accidents and ensuring worker safety, while optimizing operational efficiency and ensuring compliance with mining regulations and environmental standards. Quality management includes regular inspections and continuous improvement initiatives. Mining operations should also maintain open dialogue with surrounding communities to address concerns related to mining activities. Beatty and Cigar Workers. The Beatty and Cigar Workers Act requires employers to obtain licenses, maintain proper workplace conditions, and provide identification for workers. Compliance ensures worker safety and industry standards. The Beatty and Cigar Workers Act provides crucial protections for industry workers. Here are key questions about these regulations. What license is required to operate a Beatty or cigar workplace? All employers must hold a valid license for any premises used for Beatty and cigar production. Operating without this license can result in fines up to $10,000 and potential facility closure. These licenses enable officials to verify compliance with health and safety regulations. What is the license application process? Applications must specify the number of workers to be employed and include workplace diagrams. You must provide details about ventilation, lighting, space dimensions, and sanitation facilities. Building plans, work schedules, and protocols for material storage and waste disposal are also required. What criteria do officials evaluate before issuing a license? Officials assess workplace adequacy, your operational history, financial viability, and worker welfare provisions. They verify minimum space requirements, 50 cubic feet per person, adequate ventilation, fire safety measures, and appropriate rest areas. What is the license validity period? Licenses remain valid for 5 years and are renewable. Submit renewal applications at least 60 days before expiration. Renewals require documentation of safety inspections and worker health examinations conducted during the previous 5-year period. What facilities must workplaces provide? Workplaces must maintain cleanliness, provide potable drinking water, gender-separated toilets, adequate lighting, minimum 60 lux, and proper ventilation to prevent tobacco dust accumulation. Daily cleaning is mandatory, and all waste must be disposed of in compliance with environmental regulations. What identification requirements exist for workers? Every worker must receive a photo identification card. Employers must maintain comprehensive attendance and payment records. ID cards should display registration numbers, emergency contact information, blood type, and any health conditions. Workers should also receive employment contracts in their native language. These regulations have significantly improved working conditions in an industry historically plagued by health hazards. Regular government inspections, industry self-regulation, and worker advocacy groups collectively maintain higher workplace standards while preserving this traditional industry. Building and construction workers. Frequently asked questions. Construction sites must ensure worker safety through proper equipment, facilities, and procedures. Workers need appropriate qualifications and training. Employers must maintain comprehensive safety records and provide essential amenities. Non-compliance can result in significant penalties. Essential information about regulations protecting construction workers, explained in straightforward terms. Who can work on construction sites? Individuals with hearing impairments, vision deficiencies, or vertigo conditions cannot work in high-risk areas. Workers must undergo medical examinations before performing hazardous tasks. Minors under 18, pregnant women, and workers without proper certification are prohibited from performing certain high-risk activities. What safety measures are required at construction sites? Sites must provide secure access points with adequate lighting, sturdy scaffolding, protective measures during demolition work, and barricades around hazardous zones. All workers must use appropriate personal protective equipment, PPE, including helmets and safety gloves. Fall protection systems are mandatory for work conducted at heights exceeding 6 feet. Sites require electrical safety protocols, fire emergency plans, and adverse weather operating procedures. What are the equipment safety regulations? All equipment requires regular inspection and maintenance according to schedule. Lifting equipment must clearly display its maximum load capacity. Work areas require sufficient illumination for safe operations. Only certified personnel may operate specialized machinery. Defective equipment must be removed from service until properly repaired. Noise-generating machinery must incorporate appropriate sound reduction measures. What documentation must employers maintain? Employers must preserve records of safety training sessions, equipment inspections, incident reports, emergency response plans, and hazardous material safety data. Daily site inspection logs and special work authorization permits must be documented. All records must remain accessible for regulatory inspection and be retained for a minimum of 3 years following project completion. What facilities must be provided for workers? Sites must be equipped with first aid supplies, potable water, sanitary facilities, rest areas, and weather protection shelters. Emergency evacuation procedures and access to medical assistance must be established. Remote sites require adequate accommodations for workers. Hygienic areas for changing clothes, washing, and eating must be provided. Female workers require separate sanitary and changing facilities. What are the consequences of regulatory non-compliance? Regulatory authorities conduct site inspections to verify compliance with established standards. Non-compliant employers may face monetary penalties, work stoppage orders, or criminal prosecution for serious or repeated violations. These regulations ensure construction work environments maintain high safety standards and protect worker health. Understanding and implementing these requirements benefits both employers and workers in creating secure workplace conditions. Factory establishment. Frequently asked questions. Factory establishment requires multiple regulatory approvals, detailed documentation, and strict adherence to safety and environmental standards. Owners must understand application procedures, appeal processes, shared facility responsibilities, and ongoing compliance obligations. Clear answers about factory establishment procedures, permit requirements, and regulatory compliance obligations. What approvals are required to establish a factory? Several mandatory approvals must be secured before establishing a factory. Site approval to verify appropriate zoning and adequate distance from residential areas. Building plan approval demonstrating compliant factory layout and design. Environmental clearance confirming minimal pollution impact. Safety certifications for fire prevention and structural integrity. Operational permits specific to your industry category. All plans and documentation must be submitted to regulatory authorities for approval prior to construction or operation. What happens if my application receives no response? If authorities fail to respond to your application within 30 days, it qualifies for deemed approval status, automatically authorizing your request to prevent bureaucratic delays. Nevertheless, maintain comprehensive records of your application and submission date as evidence for potential future inquiries. What recourse is available if my application is rejected? Following application rejection, you may file an appeal within 30 days by submitting your appeal to the appropriate central or state government authority, including complete documentation from your original application, providing a detailed justification explaining why the rejection should be reconsidered, requesting a personal hearing to present your case. The government must review and decide on your appeal within 60 days. How is responsibility allocated in shared factory facilities? When multiple businesses operate within a single facility, both the property owner and all tenant companies share responsibility for structural safety and fire prevention systems, emergency evacuation routes and protocols, maintenance of common areas, adequate ventilation and temperature control, waste management procedures, security measures, utilities management. All parties should establish a formal agreement clearly delineating responsibilities and cost allocations. Is public consultation required when establishing a factory? Factories involving hazardous materials or high-risk operations typically require public consultation processes. This enables community stakeholders to understand planned operations and express concerns prior to approval issuance. What is the renewal frequency for factory licenses? Factory license renewal requirements vary by jurisdiction and industry classification, but most require periodic renewal. During renewal assessments, inspectors evaluate ongoing compliance with safety, environmental, and operational regulations. Maintain comprehensive records of all inspections and compliance documentation to facilitate smooth renewal processes. Hazardous processes. Frequently asked questions. Essential information about factories operating with dangerous materials and their safety requirements under the Occupational Safety Code. Factories engaging in hazardous processes must implement comprehensive safety protocols, including transparent information sharing, thorough emergency preparations, systematic worker health monitoring, and active safety committees. Non-compliance can result in severe penalties, including facility closure and legal prosecution. What qualifies as a hazardous process? Hazardous processes are manufacturing operations that pose significant risks to workers, the environment, and surrounding communities. These involve dangerous substances or production methods that require specialized safety measures and oversight. What information must factories disclose about hazards? Comprehensive safety information sheets in workers' local languages, detailed training programs for workers on potential dangers, and proper handling procedures, timely notifications to local authorities regarding all dangerous substances on premises, regularly updated safety risk assessments, prominently displayed warning signage in all hazardous areas, detailed documentation of previous incidents and remedial actions. What emergency preparations must be implemented? Comprehensive on-site emergency response plans and disaster control measures, scheduled emergency drills to evaluate and improve response readiness, well-marked and unobstructed evacuation routes, collaborative planning with local disaster management authorities, properly equipped emergency response teams with specialized training, reliable backup power systems for critical safety equipment, detailed records of practice drills with documented improvement strategies, coordinated off-site emergency response plans developed with district authorities. How is worker health monitored? Mandatory medical examinations before employment and at regular intervals thereafter, preservation of comprehensive health records for 40 years following employment termination, prompt reporting of suspected occupational illnesses, exposure testing. When potentially harmful situations are identified, specialized health monitoring for workers in high-risk positions, confidential communication of medical results to affected workers, systematic analysis of health data to identify potential illness patterns. What are safety committees and their responsibilities? Committees include representative members from the workforce, conduct systematic safety inspections with documented findings, protect workers' right to refuse dangerous work without repercussions, ensure prompt implementation of approved safety recommendations, provide specialized safety training for committee members, make meeting minutes accessible to all employees, formally evaluate worker submitted safety suggestions, conduct periodic reviews of overall safety performance, engage external safety specialists for independent assessments. What consequences do factories face for non-compliance? Facility operations can be suspended or permanently terminated. Management personnel may face criminal prosecution. Substantial financial penalties can be imposed. Mandatory specialized inspections for hazardous facilities. Increased insurance requirements, more stringent permitting processes. Government authority to update safety requirements based on technological advancements and newly identified industry-specific hazards. Frequently asked questions. Plantation labor rules. Plantation owners must provide housing, healthcare, child care, education, and implement safety protocols for workers handling chemicals. The law protects all plantation workers regardless of income level, with significant penalties for non-compliance. Essential information about plantation worker rights and employer obligations under current safety and labor legislation. What is considered a plantation under the law? A plantation is defined as land measuring 5 hectares or more used for cultivating tea, coffee, rubber, cinchona, or cardamom, land of 5 hectares or more with workers growing other plants specified by government notification. Any land designated by state government for specific plant cultivation. All contiguous land utilized for plant cultivation. The legislation excludes land used by owners for subsistence farming, animal fodder, or personal consumption. Which workers are protected under these rules? Protection extends to all plantation workers regardless of income level. Coverage includes permanent employees, contract workers, seasonal laborers, and migrant workers. All personnel working on plantations receive identical legal protections and benefits. What must plantation owners provide for workers? Plantation owners are legally required to provide housing with potable water, kitchen facilities, and sanitation, hygienic living environments for full-time employees, child care facilities when employing 50 or more workers, qualified personnel for child care supervision, educational facilities when 25 or more children aged 6-12 are present, medical care or government health insurance coverage, first aid equipment and emergency transportation to medical facilities, recreational facilities, and rest areas, food service operations for plantations with 150+ workers, accessible clean drinking water throughout the plantation. All facilities must comply with government-established standards. Housing must feature adequate ventilation, sufficient space, and protection from adverse weather conditions. Owners must maintain all facilities in proper working condition. What safety measures must be in place for plantation workers? Mandatory safety protocols include safe handling procedures for pesticides and agricultural chemicals, comprehensive training for workers handling hazardous substances, regular health examinations for all workers, quarterly medical check-ups for workers handling chemicals, appropriate personal protective equipment, decontamination facilities for washing and bathing, clear hazard labeling on all chemical containers, secure storage for dangerous substances, comprehensive emergency response protocols, prompt accident reporting to regulatory authorities, job rotation for workers regularly exposed to harmful materials. Safety training must be conducted in workers' native languages with scheduled refresher courses. Owners must maintain detailed records of chemical usage, toxicity levels, and implemented safety measures. Who is responsible for ensuring safety on plantations? Larger plantations must employ a dedicated safety officer. This professional develops safety protocols, conducts regular inspections, and ensures regulatory compliance. Safety committees comprising both management and worker representatives must meet regularly to address safety concerns and improvement opportunities. What happens if plantation owners don't follow these rules? Non-compliant owners face financial penalties and potential imprisonment for repeat violations, particularly for serious safety infractions. Government inspectors may conduct unannounced visits and issue compliance orders. Workers have the right to report violations without fear of retaliation, and may refuse work they reasonably believe is hazardous. Owners must display notices in local languages informing workers of their rights and complaint procedures, offenses and penalties. Frequently asked questions. This guide outlines various penalties under the Code for Workplace Safety Violations, ranging from 1-5 lakhs depending on severity. Violations include general noncompliance, obstructing inspectors, improper record keeping, and mishandling hazardous materials, with details on inspection processes and appeal procedures. Learn about the penalties for workplace safety violations under the Occupational Safety, Health and Working Conditions Code. What are the penalties for general violations? Employers can be fined 2-3 lakhs, 300,000 for breaching general safety rules. For continuing violations, they may be charged up to 2,000 additional per day. These violations include failing to provide proper working conditions or disregarding regulations about work hours and leave. What happens if someone obstructs an inspector? Anyone who hinders an inspector's work can be fined up to 1 lakh, 100,000. This includes refusing to present documents, preventing workplace inspections, or providing false information to officials. What are the penalties for not maintaining proper records? Employers can be fined up to 1 lakh, 100,000 for failing to maintain required documentation. Employers must preserve employment records, work hours logs, accident reports, and health examination records for a minimum of 5 years. What happens if regulations for handling hazardous materials are violated? Violating regulations for hazardous processes can result in fines up to 5 lakhs, 500,000 and/or imprisonment for up to 2 years. Repeat offenders face enhanced penalties. These violations include neglecting safety protocols, improper handling of dangerous substances, or inadequate emergency preparedness. What penalties apply when accidents occur due to safety violations? If accidents result from safety regulation breaches, employers may face fines up to 5 lakhs, 500,000 and/or imprisonment for up to 2 years. Penalties may be more severe for fatal accidents. Employers may also be required to compensate affected workers. How do workplace inspections function? Government inspectors are authorized to enter workplaces, examine documents, collect samples, and confiscate materials if immediate danger exists. They prioritize inspection locations based on risk assessment and compliance history. Some establishments may qualify for remote inspections or third-party certifications. Can employers appeal against imposed penalties? Yes, employers have the right to appeal within 60 days. Appeals are directed to a designated authority who may confirm, modify, or revoke the penalty after hearing both parties. Further appeals on questions of law can proceed to higher judicial courts. How do courts determine appropriate penalties? Courts consider factors including establishment size, compliance history, and violation severity. First-time offenders who rectify issues promptly typically receive reduced penalties. Repeat offenders face more stringent consequences. Where are the collected penalty funds directed? All penalty amounts are deposited into a dedicated Social Security fund used to support workers, with particular emphasis on those injured in workplace accidents. Frequently asked questions. Compounding of offenses. Compounding allows employers to resolve workplace safety violations without court proceedings by paying 50 to 75% of maximum penalties. Not all offenses qualify for compounding. and the process requires documented safety improvements. All collected funds support vulnerable workers through the Social Security Fund. Below are common questions about the compounding process under the code, with straightforward answers. What is compounding of offenses? Compounding is a streamlined method to settle violations without court proceedings. Employers pay a predetermined amount instead of facing litigation. This expedites resolution while ensuring workplace safety issues are addressed properly. Who can approve compounding of offenses? Designated officers appointed by the government have the authority to approve compounding. These specialized labor officials possess extensive knowledge of workplace safety regulations. They evaluate each case individually to determine if compounding is appropriate. How much do employers need to pay? For standard violations, employers pay 50% of the maximum possible penalty. For more serious offenses that could carry imprisonment, the payment increases to 75%. The precise amount is determined by the violation severity and the employer's compliance history. What happens after an offense is compounded? Once the employer completes payment, the case is officially closed. No further legal action will be taken for that specific violation. This results in no criminal proceedings or record elimination of court appearances, complete case closure, freedom for the employer to concentrate on safety improvements. Can all offenses be compounded? No. Certain violations are ineligible for compounding, including second or subsequent offenses within a 3-year period, violations resulting in fatalities or serious injuries cases, where the employer was previously convicted, specific serious violations designated by government authorities. These restrictions ensure proper enforcement for serious or habitual violations. How does an employer apply for compounding? Employers must submit a formal application including comprehensive violation details, documentation proving safety issues have been remediated, formal commitment to pay the stipulated amount, disclosure of any previous violations, evidence that workers were consulted regarding safety improvements. Inspectors will verify the complete remediation of all safety concerns before granting approval. Where does the money from compounding go? All funds collected through compounding are directed to the Social Security Fund, which provides essential support to informal sector workers. This ensures that penalties from workplace safety violations directly benefit vulnerable workers. Employers opting for compounding must demonstrate a genuine commitment to workplace safety enhancement. This typically involves participation in safety training programs or implementation of improved safety management systems. The primary objective is not penalty collection, but fostering safer work environments. Social Security Fund FAQs. The Social Security Fund provides essential financial and social protection for informal workers through government-managed resources. It delivers healthcare, education support, and various benefits, with priority given to workers in high-risk occupational sectors. Clear answers about how the Social Security Fund supports workers in the informal economy. What is the Social Security Fund? The Social Security Fund is a government-established resource dedicated to supporting informal workers without access to traditional employment benefits. This includes individuals working in small retail establishments, agricultural settings, domestic service, and other informal sectors. The fund serves as a crucial safety net when these workers face financial hardships or emergencies. Who manages this fund? The government establishes the fund, which is then administered by a diverse committee comprising government officials, worker representatives, and subject matter experts. Individual states also have the authority to create state-level funds to address the specific needs of local informal workers. What are the sources of funding? Penalties collected from labor law violations, proceeds from compounded offenses, allocations from the central government, contributions from employer organizations, donations from individuals and institutions, corporate social responsibility initiatives, additional government-approved sources. What benefits does the fund provide? The fund supports workers through various programs: healthcare services for workers and their families, maternity benefits for women workers, educational assistance for workers' children, retirement and pension support, disability assistance and accommodation, skill development and vocational training, housing assistance, particularly in urban areas. How is accountability maintained? A dedicated oversight office monitors the fund's operations. Regular audits ensure financial integrity and prevent misuse of resources. Annual transparency reports detail expenditures and outcomes. Digital systems track all financial transactions. Workers have established channels to report concerns or irregularities they observe. Is fund transfer between schemes permitted? Yes. Resources may be allocated to complementary welfare schemes that also target informal sector workers, provided the transfers maintain the primary objective of supporting unorganized workers. How are benefits prioritized and distributed? The fund prioritizes workers in high-risk occupations such as construction, domestic work, and agriculture before expanding to other sectors. Community-based organizations help identify local priorities and needs. The fund implements ongoing impact assessments to evaluate program effectiveness and make necessary adjustments. Why is this fund significant? Informal workers typically lack access to conventional social protection systems when facing adversity. This fund creates a vital support structure during emergencies, illness, or retirement. It acknowledges the essential contribution these workers make to the economy, while helping them maintain financial dignity and security throughout their lives. Frequently asked questions. Miscellaneous provisions. Clear explanations about how the code applies to everyday workplace situations. This section clarifies practical aspects of code implementation, including delegation of authority to state governments, age verification protocols, burden of proof in violation cases, essential record-keeping requirements, and protections for individuals who report violations. Who can implement the code? The central government may authorize state governments and other bodies to implement specific parts of the code. This approach allows for regional customization while maintaining central oversight. The central government reserves the right to revoke these delegated powers at any time through official notification. How is a worker's age determined under the code? A worker's age can be verified through any of these documents: Aadhaar card, school certificate, birth certificate, passport, or other government-issued identification, voter registration records, medical examinations. Permitted only when documentary evidence is unavailable. The designated medical authority has the final determination regarding age verification. Employers must maintain age verification records throughout employment and for 3 years after termination. Who bears the burden of proof in code compliance? In alleged code violations, the accused party must demonstrate that compliance was not reasonably feasible. This reverses the standard legal burden where accusers typically must prove wrongdoing. Courts consider contextual factors, including available resources and industry standards when evaluating compliance. What documentation should employers maintain for compliance? Employers should preserve safety committee meeting minutes, employee training documentation, workplace inspection reports, remedial action records. Age verification documents. Are whistleblowers protected under the code? Yes, the code safeguards workers from retaliation when they report code violations, provide testimony in code-related proceedings, decline to work under unsafe conditions, engage with safety representatives, document safety incidents or near miss events. Workers facing retaliation may file a complaint within 90 days of the adverse action. Employers found guilty may face financial penalties, reinstatement obligations for terminated employees, or criminal charges in severe cases. What is the time frame for state governments to establish rules? State governments must formulate implementation rules within 90 days of receiving delegated authority from the central government. What is the deadline for age verification? Employers must complete age verification within 15 days of a worker's employment commencement. Does whistleblower protection extend beyond employees? Yes, protection provisions extend to non-employees who report code violations in good faith. These provisions ensure effective code implementation, fair enforcement, and equitable dispute resolution, while streamlining compliance requirements for all stakeholders. Common licensing system. Frequently asked questions. The new common licensing system streamlines business compliance by consolidating multiple labor permits into a single application. With expedited processing times, online submissions, and significantly reduced documentation requirements, this system delivers tangible benefits to both businesses and workers. Below are straightforward explanations about the new licensing system, designed to simplify regulatory compliance while maintaining strong worker protections. What is the common licensing system? It's a streamlined framework that consolidates multiple licenses into a single permit, rather than applying separately for factory operations, Beatty cigar manufacturing, and contract labor authorizations. Businesses can now secure all necessary permissions through one comprehensive application. How long does it take to get a license? Licenses are typically issued within 45 days of application submission. If no decision is communicated by this deadline, your license is deemed automatically approved under the deemed approval provision, effectively eliminating prolonged waiting periods. How do I apply for a license? Applications can be submitted either online or in physical format, though digital submission is recommended for faster processing. You'll need to provide standard documentation that satisfies all license categories, significantly reducing paperwork requirements. What if my license application is rejected? You may file an appeal within 30 days of rejection. Appeals are resolved within 30 days, and you have the right to request a personal hearing to present your case. If unsatisfied with the appeal outcome, you retain the right to pursue further legal remedies. How are licenses stored and tracked? All licenses are maintained in a centralized digital database accessible to authorized officials. You must prominently display your license number at your workplace and include it in all official correspondence. The system provides automated renewal reminders to ensure continuous compliance. What happens to my old licenses? Existing licenses remain valid until their expiration date. Upon renewal, you'll transition to the new system. A 90-day grace period is provided for licenses expiring shortly after implementation of the new regulations. Can I change my license details after approval? Yes. Minor modifications such as business name or address changes are processed within 15 days. Substantial changes, including operation type alterations or significant workforce expansions, require up to 30 days for approval. Urgent modifications for seasonal operations are expedited and processed within 7 days. What are the benefits of this new system? The system reduces administrative burden and processing time by approximately 40%. It enables businesses to shift focus from navigating complex bureaucratic procedures to enhancing regulatory compliance and workplace conditions. Implementation data shows a 30% increase in compliance rates among registered businesses. This modernized licensing framework facilitates regulatory adherence while maintaining robust worker protections. The efficient process generates significant time and cost savings for all stakeholders in the labor ecosystem. Frequently asked questions. Exemption provisions. The code permits temporary exemptions from certain regulations for special circumstances, including seasonal businesses, emergencies, and new factories. All exemptions and corporate worker protections are transparently documented and typically include specified time limits. Below are common questions about exemptions under the code. These provisions offer necessary flexibility while maintaining worker protections. What are special case exemptions? The government can exempt certain businesses from specific code regulations. This applies to seasonal operations, such as agricultural harvesting, tourism in designated areas, and manufacturing facilities in economic zones. All exemptions include mandatory conditions to safeguard worker rights. Can new factories get exemptions?